Good morning. This is the 10 a.m. civil calendar for courtroom 304, Clayton County, Georgia. I'm Judge Tammy Long Hayward. I'm going to call the calendar and get announcements from everyone. First case on the calendar is Emmanuel, Germany versus Timothy, looks like Schrappa.
Good morning, Your Honor. Matt Hollingsworth, I have a plaintiff.
Right.
Good morning, Judge. James Hankins on behalf of the defendant.
All right. So this is an auto accident. Sorry, my iPad updated and hasn't been the same since. All right. So this is a rear end auto accident. And this is a motion for summary judgment.
Partial motion for summary judgment, Judge, just relating to one claim, the permanent hair loss. And so it's a partial motion. It has nothing to do with the negligence issues to address your comment, but it's more to one of the damages claims.
Okay. One second. Let me call the rest of the calendar and then we'll come back.
Okay, thank you.
No problem. Our next case is Darian Walker. Tony Greer is attorney for Darian Walker. Is that correct? And Cheryl Ann Tate and South Tire South Inc.
Good morning, Your Honor. Vanessa Franco on behalf of defendants.
All right. Premises liability case?
That's correct.
Next is Huntington Debt Holding versus Shelton Foreman.
Daniel Green for the plaintiff, Judge.
All right.
I didn't see Mr. Foreman, unless that's...
Anyone here on behalf of Mr. Shelton Foreman?
Your Honor, this is on our pending motion for summary judgment based on failure for admissions. So if he doesn't sound, my side would take less than 20 seconds.
I got you, Mr. Green. Whitney Barkley is rescheduled. Whitney Barkley versus Stephanie Collier. That case has been rescheduled. So if there's someone here for that case, you're free to go. And Devontae Taylor and Denise Tuckenberry versus Michael McKinney.
Good morning, Your Honor.
All right, I see Ms. Tuckenberry. Next is One Financial versus Kenley Horton.
Here, Your Honor.
Judge, is that One Main Financial?
I'm sorry, One Main Financial, yeah, versus Kenley Horton.
Yes, Judge. And who's the listed attorney on that one?
Sarah Lewis.
That's me, Your Honor.
All right, and Mr. Horton?
Yes, Your Honor.
Okay, so I see a Greg Horton and a Kenley Horton, but Mr. Greg Horton, you're not related to this case?
No, I am. I'm the older brother of Kenley Horton. I've taken responsibility of his financial responsibilities due to some of the issues with mental health crisis that he had been experiencing. So that's why I'm here.
No problem. So we'll go ahead and do Mr. Green's cases because those will be very quick. And then once we finish those, we'll go to the top of the calendar. Okay. All right. Okay. So Mr. Green, you have Huntington Debt Holding versus Shelton Foreman. The court is sounding for Shelton Foreman. Mr. Foreman is not present and no one has answered on his behalf. Go ahead, Mr. Green.
Your Honor, I would just move to have the court just review our pending motion for summary judgment and issue an order on the pleadings. I believe a proposed order is in it. Again, this was failure to respond to admissions. We did provide proof that we served the admissions.
All right, so Huntington Debt Holding versus Shelton Foreman. This is a breach on a contract, on a credit card agreement. The complaint was filed on January 20th of 2025. The defendant was served by a notorious service. He answered pro se. His answers and affirmative defenses did not present a cognizable defense that would allow the court to find that there's a genuine issue of material fact. Do you have the amount that is requested, or are you just asking that the court rely on the pleadings, Mr.
No, Judge, I have that if you give me a few seconds. So, Judge, we're seeking a total of $11,965.41 in principal and $273 in court costs.
All right. $11,965.41 plus $273 in court costs. The court will find for the plaintiff on the motion for summary judgment and award those costs. And we'll go ahead and present and the order has been presented. We'll go ahead and sign that and get that out.
Thank you.
You're welcome. All right, and for the One Main Financial versus Kenley T. Horton, Mr. Horton is present, and also on his behalf is his brother who, so Mr. Greg Horton, have you gotten either a conservatorship over your brother, or?
That's what I'm working towards. Actually getting power of attorney with for his financial and his health. There's two different power of attorneys that I'm trying to obtain, and I need to find legal representation because as I'm digging, I'm finding out instead of responding specifically to this case, there may be other cases out there that were done during this period of time that I kind of need to attack it holistically and need time to kind of gather legal representation to see what the approach should be.
Okay. Well, you can contact the State Bar of Georgia, and they will have individuals that work with respect to probate court, elder care, conservatorship, that kind of thing. So that's kind of what you're looking for. And they may be able to help you find an attorney to assist you with that. Mr. Green, can you go ahead and lay out the case so that, well, I'll go ahead and tell you what I have. So this is One Main Financial Group, which is a credit card agreement. And the complaint was filed on March 20th of 2025. The case was initially with Judge Jones Parker, and somehow it got transferred to me. The defendant was served personally on March 24th of 2025. He answered pro se, so he filed something on May 12th of 2025. On December 22nd, the court recused in the order, Judge Jones Parker recused and the order came to me for this case. Motion for summary judgment was filed on December 22nd, and January 16th, the rule nisi, which brought you here to court. So, Mr. Green, go ahead and tell us what's going on in this case.
Judge, I don't have the balance in front of me on this case, Your Honor. I know it was just a One Main Financial straight loan. And I can give Mr. Horton the number to our office if he wants to just call directly to reach out.
All right. Mr. Horton, would you be wanting to do that?
Yes, I'll at least make contact. I've made a couple of calls, but
okay. Did you get all of the information that was filed into the case?
No, ma'am. I think I was aware of a balance somewhere in the neighborhood of $3,000 for this loan.
Okay, this is what you can do. You can call the state court clerk's office for Clayton County. The clerk has a unique name, so when you Google it, you'll be able to pull her name up and get the website. But her name is T-I-K-I Brown, Tiki Brown.
Okay.
All right. And so when you get that, you can ask about how to access the information that's been electronically filed in this case. You can also ask if there are any other cases pending in Clayton County.
Okay.
Okay, so that should be able to help you. All right. So Mr. Green will review the documents that were filed. And then Mr. Horton, Mr. Green, can you chat him your information so that if
I was doing that right now. Yes, Judge.
Okay, so before you get off the call, go ahead and write down everything that Mr. Green is chatting, because it won't, like you won't be able to access it after.
Access it. Okay, thank you.
All right. Also, Mr. Horton, there's an organization called NAMI, National Alliance for Mental Illness, which is a omnibus support group for adults and children with mental health issues, and also for their families. Anyone who's trying to, advocate on their behalf. Georgia has a very strong chapter, so it's GANAMI.org, Georgia NAMI. And so they should be able to assist you with some of the things that you're trying to get done.
Okay, I appreciate that, Judge. Thank you.
All right, and thank you for
Thank you, Judge.
taking the opportunity to make sure your brother's okay. All
Thank
right. All right, so we'll get back to you. Mr. Horton, did you want to, for ease of sending out orders, because we can email you a copy of whatever we do in this case, if you will send your email address by chat to my staff attorney, Ms. Kiara Powell.
Will do.
Okay, so if you chat your email before you leave, and then she'll attach that to this case so that you will get the information.
Okay, thank you, Judge.
All right. So, all right, Mr. Horton and
Thank you,
Mr. Horton, both of you may be excused, and Mr. Green, I believe our business is complete. All right. Okay, Emmanuel Germany versus Timothy Schrappa. Am I saying that properly? I hate messing up people's names.
Yes, Judge, I believe that's his correct pronunciation, yes.
Okay, thank you. All right, so Mr. Hankins, is this your motion?
Yes, ma'am.
Go ahead.
May I
My staff
proceed?
attorney has got me doing hyperlinks, but my iPad is not communicating with me right now. Go ahead, sir.
May I proceed, ma'am?
Yes.
Okay, thank you. Judge, good morning. James Hankins on behalf of the defendant. I'm going to briefly talk about the accident just because you had asked a question. This is not a rear-end collision. This is a disputed liability case, kind of sideswipe type of collision on the interstate. It's not really germane to the motion, but I did just want to address that since you had mentioned that. There was a police investigation. Officer didn't issue any citations or find anybody at fault because of the conflicting statements. But today we're not here to discuss any negligence issues. We didn't file for a partial motion on negligence. The motion before the court really is limited to any claim for permanent hair loss. And so in the record, we put into the record Mr. Germany's discovery responses and photos and his testimony. And he's claiming that, I guess, his dreadlocks got cut off during this December 2021 collision. And the motion really is related to permanent hair loss, permanently damaged hair follicles. Hair doesn't grow anymore. Permanency is the issue before the court. And so that is what we have moved for partial summary judgment on, is just to prevent him trying to show, hey, I got permanent hair loss, jury, and we want you to award damages based on permanent hair loss.
Oh, okay. What was the mechanism of that caused the damage? So was his hair caught in the door? Was there?
I believe that is what he's claiming in his deposition, is that I think his hair got caught in the window of the door during the collision and it got ripped up or ripped partially out. We're not, again, the motion is not really relating to whether or not the accident caused hair damage. The motion is related to permanency. We're 4 years and 2 months later, and we're just trying to move for partial summary judgment on him claiming I got permanent hair loss. There's no there's no medical treatment, there's no experts to say, yeah, Mr. Germany has permanent hair loss, his hair's never going to grow back. That is what the motion is for.
I think they call him a trichologist, specialist for hair follicles. So there was no one to opine an opinion that there would not be a possibility that his hair would grow back.
That's correct, Judge. So that's just the motion is we are just going to try to move for summary judgment on that claim, the
I got
permanent.
you. I got that is the sole claim, and I got that it's sort of tangential to the liability issue with respect to the car accident. But I'm trying to understand the mechanism of damage that would have caused this gentleman to, in a car accident, to have permanent hair loss or damage to hair follicles such that his hair wouldn't grow back. Mr.
And I would
Holland?
agree with you, Judge, what I would do is, I use these motions only in cases where the law does require something more than just testimony. So I think during the calendar call, someone mentioned premises liability. Don't even know anything about the case, but I'm sure if they fell down and said my back hurt afterwards, then they could stand up there and testify if the case got to a trial and say my back was hurt in this accident. It didn't hurt before. That is different than the issue in this case in the sense of this permanency, because the law would require something more in this case on this claim. And that's kind of the best analogy I can give. I share your skepticism in terms of just the initial, the hair, but again, that's not the motion we're talking about. I'm not moving for summary judgment on saying he's saying this is what happened in the accident, his hair got ripped out and whether or not it's related. That's not the issue before the court. It's just he cannot testify and claim, hey, yeah, my hair is never going to grow back. It's 4 years and 2 months or whenever on the trial calendar. And he's going to say 4.5 years later, yeah, it's all related to this collision.
Okay. Mr. Hollingsworth?
Yes, good morning, Your Honor. For clarity on the mechanism of injury, it was a rollover crash, and I believe my client testified that his hair got caught in either like the sunroof or the window. It was obviously in that moment, he wasn't exactly sure, but he has dreadlocks, and the locks are what was caught when the car was rolling over. But to address the defendant's motion, this is a very narrow issue, of course, but it fails primarily because there is record evidence of the injury. And for the purpose of summary judgment, at least, that should end the inquiry. Not to get into the brief specifically, but the court must construe the evidence in light most favorable to the non-movement. And the defendant bears the burden here. And the question is whether there is evidence, and there is. There's direct evidence of the hair loss caused by the crash. The defendant's own brief essentially includes that, and it's in my client's deposition where he testified that he lost a small section of his hair on his right side, and he said to this day it's a lot shorter than the other parts of his hair. Critically, when he was asked about the condition of his hair 3 years later, he said, I still have a section on this side of my hair that is like significantly shorter than the other sections. There was no testimony about permanency. It was simply that his hair has not yet grown back. His interrogatory responses confirm that he had about 25% hair loss on that right side. We've produced photographs showing the before and after differences, and that's evidence of an injury. It's evidence of timing. It's evidence of causation and the ongoing effect. That should be able to get to a jury. Expert testimony is not required for a visible, immediate physical change. The defense's motion hinges on the premise that we need expert testimony, but Jordan versus Smoot and other cases make it pretty clear that if there's no significant lapse in time and the injury is within common knowledge, that we don't need expert testimony. And here, the hair loss occurred during a rollover crash. The vehicle flipped, the roof scraped the ground, and my client testified that he noticed the hair loss at his hospital. We don't need a dermatologist to understand that hair can be torn, scraped, or cut off during a violent rollover crash. There's no complex neurological causation issues. This is not some sort of toxic exposure claim for hair loss. This isn't a latent medical condition. This is observable hair loss from a layman's perspective, contemporaneous with the crash.
So is your client claiming that his hair is not growing back at the rate that he expected and that he's seen with the parts that were not damaged?
He's really just claiming that his hair was damaged and it still hasn't grown back in full. There's not a specific claim for permanency. and really this would just fall under a non-economic damages claim for disfigurement, physical altercation, embarrassment, humiliation, and or temporary physical change. We don't have to have a medical bill to prove that. We certainly don't have to have an expert. But the permanency is not required to recover general damages. Temporary disfigurement is compensable. And if the defense wants to prevent the plaintiff from talking about permanency, that I think the proper vehicle would be a motion in limine. But he should, and that any temporary disfigurement or temporary hair loss would be a jury question, a jury question on duration and damages. Where even if we ultimately stipulate there's no permanent hair loss, that does not eliminate a claim for prolonged visible temporary disfigurement. That's a fact question. And so essentially, this is a fact resolution issue or a credibility weighing issue, and that's what summary judgment prohibits. If the defense believes the injury is minor, they can cross-examine my client at trial. If they believe causation is weak, they can argue that to a jury, but this isn't ripe for summary judgment.
Judge, just real quick, I'd like to respond. The argument seems to conflate kind of the questions you have in terms of mechanism of injury and the permanency. And again, the motion for summary judgment is focused on the permanency. And when you ask a direct question of opposing counsel whether or not his client is claiming it, you got a kind of a non-answer. That's the reason why we can file for summary judgment at this juncture, because the law doesn't, to use my analogy earlier, you got a fall and someone claims my back hurts. Obviously, they can go to court and say, yeah, my back hurts. I hurt my back in this fall. They couldn't say a herniated L whatever, right? But they could say my back was hurt.
Okay.
The law does segregate.
I hate to interrupt you, but so just so you're clear on, so I think in pictures, that's how my mind works. So when you made your argument, and when I read it, I'm thinking, okay, did he have like was it ripped out from the scalp such that he had a bald spot and the hair is not growing back? If so, that would be evidence of maybe a permanent injury. But what Mr. Hollingsworth is saying is that, yeah, he lost hair in the collision. There was a change to his physical appearance occasioned by the collision. He may not be saying that his hair is permanently not going to grow back, but has not grown back to the length or as quickly as he expected or as he has seen with other parts of his hair. And I'm not sure that that's a permanency issue as much as it is an argument that there was damage caused by the collision, which is part of all the other damages that he's claiming.
And Judge, the claim though is we tried to get a stipulation just to say you're not claiming permanent hair loss. I wasn't with Mr. Hollingsworth because I was working with a different attorney. I guess he just got, I think he entered an appearance recently.
Okay.
We couldn't work that stipulation out. We have moved for summary judgment because we got a non-committal. Well, I can't agree to the language in this stipulation. So that's why we filed the motion. This is the type of claim that on a permanent hair loss, I've had surprisingly a lot of cases. I've had hair relaxer cases. I've had various types of hair damage cases. There are people that will opine and say, this is related to this based on this. And this case, in my mind, that is different than the analogy I used earlier in terms of I fell down and hurt my back, or I fell down and I hurt my hand or knee, whatever it is. The jury needs expert testimony, like in my hair relaxer cases that I've had, to say this is related to you putting this chemical in your hair for 2 minutes too long or 5 minutes or whatever it is. So, but again, that's the basis of the summary judgment, just that one issue.
Let me think about it, because I think there's a pretty close question. I don't know that from what Mr. Hollingsworth is saying, I don't know that he's saying that he has permanent scalp damage that would cause his follicles not to produce hair. I think what he's saying is that he did suffer a change in his appearance based on hair that was damaged per the collision, and the fact that it was a rollover collision and his hair may have gotten caught against the roof or against the sun visor or whatever. So let me look at it again and make a determination about
Thank you,
whether I'll
Judge.
grant or deny the motion.
Thank you, Your Honor.
All righty, thank you.
It would be excused.
Yes, you may.
Thank you very much.
All right, next is Darian Walker versus Cheryl Ann Tate and Tire South.
Yes, Your Honor. I know this Tony Griffith, the plaintiff. I know that this is defense's motion. However, I would like to save everybody some time. So now that we have gotten through a bit of discovery, the plaintiffs are no longer going to pursue the claim against Ms. Tate. We do believe that she was out of possession. This motion was filed before discovery was able to be completed, I should say. Well, we're still not completed. There's still a couple of depositions that need to be taken. We filed a consent motion with the court, waiting for the order to be signed. But as far as it relates to Ms. Tate and the claim is against her, plaintiff, is willing to dismiss that claim. I'm not sure if Your Honor wants to do that by granting the defense's motion for summary judgment, or will allow the parties to just file the dismissal without prejudice
Okay.
with the court.
Miss Francois, you tell me what your client would prefer.
Well, my client would absolutely love a dismissal with prejudice.
All right. So, Ms. Greer, if you would be so kind as to file that, if you can get it done within the next 7 days, I would hope that we could get that done.
Of course, we'll try to get it done today, actually. Thank you, Judge.
All
And you
right,
said make that with prejudice, not without?
Yes. Yeah, if she's coming out, unless there's some reason to hold her without prejudice, is that a concern?
Well, that's just always my, my safety mechanism as a plaintiff's attorney, just to not let anybody out until the case is resolved with prejudice, because there is still some discovery to be done, but discovery that has been done thus far does not, point at her anyway, which is why I'm willing to let her out. But obviously, it's the court's decision, because there's still a couple depositions that need to be taken that I need to take of the defendant's employees, I should say.
In Your Honor, I must add, I can't imagine in what universe these depositions will change Ms. Tate's status as an out-of-possession landlord. The commercial lease that was attached to our motion for summary judgment lays it out, and OCGA 44-714 absolutely, outlines her status as an out-of-possession landlord. So we definitely ask that it is with prejudice, or if not, the court to grant our motion for summary judgment, please.
Let me ask this. Does she have any fiduciary interest in Tire South?
She serves currently as the landlord.
Other than her status as landlord?
I'd have to dig into that a little bit more specifically to provide the court a clearer answer. Her currently, as far as based on the conversation and the knowledge and the documents that we have, her only connection to that property is serving as a landlord.
Okay. Yeah, so that's where the motion, the dismissal with prejudice or without prejudice would hinge. If there is any possibility that she's a shareholder, owner, anything of Tire South, or that she has any interest in Tire South itself, the business, then I would say do it without prejudice. If there is no possibility that she has any other fiduciary interest in the property other than owning the building from which Tire South leases the space, then I'd say that it's without prejudice. I mean, it's with prejudice.
And if the court may allow, Your Honor, I absolutely want to cross all my T's and dot all my I's before providing you with an answer as it relates to that. I would hate to misrepresent her.
No problem. I get it.
Owner.
I'm sure that was not a question that was top of mind on this. So, all right. So let's do this. Let's give y'all 7 days. Y'all talk. If you can be assured, Ms. Greer, that she has no other interest in the property other than being an out-of-possession landlord, go ahead and cut her loose and then proceed with the rest of the trial.
Perfect. Will do, Judge. Thank you.
All right. Thank y'all.
Thank you, Your Honor.
Have a good one.
All right. Take care.
You too.
Bye-bye.
All right, next is the okay. Devontae June Taylor and Denise Buckenberry versus Michael, looks like Corday McKinney. All right, so Ms. Tuckenberry, you are back. Mr. McKinney, you are here. So previously, it is my understanding that we had what we believe to be service was made on you, Mr. McKinney, and you didn't appear for the hearing, so we proceeded. I heard Ms. Tuckenberry's presentation of evidence, and there you were not here to dispute that, so the court did a motion to for default. It's my understanding that you challenged service in that you believe that you were never served and never received service of process. So let's talk about that first. Because this is on your motion to set aside the default. All right, you're trying to unmute, so let me see if I can send you a prompt that might help. Mr. McKinney, what you're looking for is a old-fashioned looking microphone, and it should appear red with a little slash over it. If you click on that, or if you click on your picture, there should be a block of a blue block with about three white dots in it. Click on that, and it will say unmute. Otherwise, you may have to leave the hearing and come back in. Still not doing it. Sir, listen, if you will, there you go. Hold on. Da-da, you did it. Go back. There. Now speak.
Yeah. Okay. Can you hear me now?
I hear you.
All right.
All right.
I'm sorry.
So, sir, this is on your motion to set aside the default judgment in this case.
Yes. Yes, ma'am.
So tell me, okay, so here's the thing. When service of process is done, the person who serves the summons and complaint then does what's called a return of service. That return of service is filed with the court, and it essentially gives the details of how you were served. My understanding is that there was service, I guess notorious service at a place where you were believed to have resided. Now, tell me about why you believe you were not properly served in this case.
I never received any service at a place that I resided. The address that I had and I lived at when I met Ms. Stuckenberry, I hadn't received any kind of service there. But what I can say, Your Honor, is this. This is a little bit of a complicated process that went on for about a year between me and Mrs. Tuckenberry. And toward the
I
end
remember y'all knew each other in high school, y'all reconnected, and then there was the thought of starting a business or several businesses, and then money was given, which may not have all been Miss Tuckenberry's money. Some of it may have been money that was attributable to her disabled son. And money was given, and no business ever showed up. That's what I heard.
That wasn't.
Okay, but I don't want to talk about that right now, Mr. McKinney. What I want to talk about is the service, because that determines whether I open default and hear your claims.
Right. Yeah. What I can. The reason why I brought that up, Your Honor, is that because it's relevant to what it is that I was trying to explain. Toward the end of our relationship, it got kind of hectic, and she started doing some things, and so I stopped talking to her. But what ended up happening is that I blocked her on my phone and all the messages services. When I did go back to my phone and unblock it, when I found out about all of this, I do see that she sent a text message saying something about this hearing. That was the only indication or anything that I had ever received from her about any kind of hearing or anything like that.
Miss Powell, if you could pull up the image of the return of service for me and send it to me.
Yes, ma'am.
All right. So, Mr. McKinney, you said that the place where you lived when you and Miss Tuckenberry first started speaking to each other, you no longer lived there at the time of service.
I was in the process of moving out of there. I was at another place, but I wasn't there that often. But I went there like once a week to check the mail and make sure that everything was fine. I never got any mail there.
Okay. So, and you said that the only way that you got notice of this proceeding was through when you unblocked your phone and Miss Tuckenberry had sent you a message?
She had sent a message to my phone about the
Okay.
hearing.
And at that point, when you received the message, what did you do?
At that point, when I received the message is during the time when I went to the bank and found out, and then I went backwards to look at the text messages and things like that, unlock the phone. That's when I filed this motion, when I went to the bank and started making calls.
Okay, you went to the bank for what purpose?
I go to my bank all the time to make
Yeah, but what did that have to do with this and service?
well, because what happened when I went to the bank is that my account was frozen.
Okay. So that's what got
I can't hear you again.
I said that's what got your attention.
That's what got my attention, yes.
All right. Ms. Powell, you have that?
Almost, Judge.
Ms. Tuckenberry, who did you use to serve process on Mr. McKinney?
I used 11 different methods to serve process. The first one I started with the sheriff. And I talked to the Lake County Sheriff because he was living, his last known address to us was Indiana. So I talked to the Lake County Sheriff's office and I was setting it up so they could go to his house and send him the first service. Actually, it was, the first service. So
Okay, what address did you have for Indiana?
5946 Holman Avenue or something like that. Yeah, 5946 Hohman Avenue, apartment 515, Hammond, Indiana 46230.
Okay, and why did you believe he was at that address?
That's where I sent most of the money to. The checks through the mail went there, and he received them from there. And other mail.
Okay, and so when you served him through the sheriff, what did the sheriff say occurred? Like, did he say that he was able to serve him or leave the paperwork? What did he report?
Okay, I was setting up the paperwork for the sheriff, and then I had a detective, and he sent the process server over to this address. And the process server talked to the owner of the building, and he informed him that Mr. McKinney had moved in August of 2024. So I canceled with the sheriff and I started talking to the county clerk to see what to do next in Indiana and then in Illinois. And they said that I can do trying to think of the name of that kind of service, like non-traditional or something like that kind of service where I could do email is legal in Illinois. I was in 2 states. He has an address in Illinois and he has one in Indiana. And the Indiana one I was more familiar with. So let me see. So I stopped the sheriff from going out because I would have had to pay for that. So I called them back and talked to them and told them that he had moved, and I started going forward with the process server. And so in 2024, the process server had went to Mr. McKinney's job and he took a picture of him. And that was so I could make sure that he had the right person, to serve and that he was still at the job. And did you get my the service files that I sent in?
Miss Paula's pulling those things up. So go ahead
Okay.
and just continue to tell me what happened.
Okay, so he got the picture, so he knew who he was. And then, okay, he went to the apartment. He left court documents. Okay, when he went to the apartments, he left court documents with the owner because the owner, by this man talking to him about Mr. McKinney, he thought something bad had happened to him. So the process server told him, no, he's being sued. So he left some paperwork with him. He still went to 515, the apartment that the defendant used to live at, and he left some papers with a young man who said that he was Michael. So I don't know who that was, but he did.
Really?
He left some papers there, and he left some papers with the owner. And let's see. Okay, talk to the owner. Cancel with the sheriff. Pictures. Okay. When Attorney Powell pulls up my file, you'll see that I had two pictures of the text messages. That's what I did next. I had sent text messages to Mr. McKinney with the summons, with the claim, and with some more court documents telling him, I told him to read them and I asked him to answer the court. And this was back in like March the 25th, around March the 25th. And then I talked to the court clerk, like I was saying, so I could.
March 25th of 2024?
Yes. No. March the 25th of 2025.
Okay.
After I filed the paperwork with Clayton County with Deputy Ashley,
Okay.
then I
So you
texted
sent
him.
You sent him a copy of the summons, the complaint. Had this been a text? Had these been messages you've used before? Like you were able to communicate with him over the number that you sent the text to?
Yeah, I had his phone number, and if this is what you're saying, I took pictures of the court documents from Clayton County and I sent them to him right away so he would know he has court. He has, a hearing was coming up.
Okay.
And so this was March the 25th. This was during that, you file the paperwork and you got so many days to get in touch with him and so many days for him to answer. So that was more service.
So now the Holman Avenue, 5946 Holman Avenue, what was your thought process? Like who lived there?
Mr. McKinney.
Okay, and how did you know he lived there?
We were talking about business and other things like that. And that's the address that he gave me. And I sent him a bunch of paperwork. I sent him a lot of things, a lot of money went to that address, to that mailbox, and he got it and he put it in the bank, cashed it.
Well, that was the 5946 Holman Avenue.
Yes.
Okay, so you sent money there, and he cashed the checks.
Yes.
Okay. All right. So what was the next thing you did?
Okay, let me see. I sent him the text messages, and on the text messages, you can see when somebody is typing or when they received it, like 2 check marks. So he received it, and I put in there in the text message for him to answer the court, March the 25th. So he got it, so he knew about it, and then then I'm back between Indiana and Illinois. I talked to the court clerk in Illinois about the sheriff couldn't serve him. So I know, from hearing the last hearing, I think the sheriff's service is really important to you, so I told the court.
Yeah, it's the law. It's sheriff's service or service of process spy
Mhm.
process server. Yes,
Mhm.
ma'am.
So I couldn't get the sheriff to go to his Indiana apartment. So I talked to the court to ask them what to do because I felt like the defendant was evading service because when he moved from Hohoman Avenue, August 2024, he didn't forward his address with the post office. So everybody asked for the last known address. So that's what I had to work with and his ex-wife's address. This is the address that he put on his information for you all for this court hearing is his ex-wife's. He says he lives there. That's his
Okay,
address.
What's the ex-wife's address?
What's her address? I know it's in Country Club Hills.
It's 5946. I mean, no, not
No.
5940. 17650 Springfield, Country Club Hills.
Yeah,
Her and her
that's
husband lived there for 20 years.
okay, but okay, I don't know, but I'm just say something. He put that as his address, like current, like today, like now. And his ex-wife and her husband live there. So I don't know what's going on with that, but I did send a service letter to her.
Okay, and who's the ex-wife?
My ex,
Yes.
Mr.
my
McKinney?
ex-wife.
Hold on, Mr. McKinney.
Okay,
Okay.
Because I got to figure out what efforts she did to serve you, because you're claiming you didn't get any of these.
I did. I got the phone situation once I went back to my phone. I don't live in Country Club Hills, and when I was living over there in Indiana, I wasn't even living there all the time because I was in a relationship that I had told her about. So I was living with my girlfriend at the time. I wasn't even living in the apartment. It was just apartment that I had in case I had to go back to. No landlord over there ever gave me any papers. I went back there. I cleaned the whole apartment out and went, you have to show them after you clean the place out to make sure that everything is fine. I spoke to the people there. They never said anything like that. And the address that she's talking about over there was stuff that she sent there that never came to me. That's the part that
You never
she's not.
cashed checks.
Yeah, there was a mail that she sent that never came to me.
Okay, you didn't hear my question. She sent checks to the Holman Avenue. You cashed
Yes.
those. She sent checks to the address in Illinois. You cashed those.
No, she never sent a check to anywhere in Illinois.
Okay, never sent them to the apartment that you're talking about.
No, that's Indiana. She never sent anything to any place in Illinois. No
So
check, no financial things to any place. What she did was this: she sent like a cash thing where you send to the bank and it went into the wrong account. She did that, but she never sent it.
So Mr. McKinney, you just said that you don't live at Country Club Hills, but that's the address that you just put on the filing today for this motion to open default.
Yeah, this is the thing, Your Honor. I'm disabled. I'm disabled. I suffer from mental illness. My daughter lives with her mother. That's my payee, the one that takes care of me. So all of my mail and stuff goes to her, and so she still uses that address. That's why I sent it over there to her, to that address. There, at one point I didn't have no place to stay because the relationship had dwindled out. And I didn't have anywhere to stay. So my daughter was taking care of all that. She still lives with her mother. And my daughter, I got a couple of daughters that live over there. One of them has mental illness just like I do, but my other daughter, the one that's healthy, she lives there with her mother. My mother is married to a man she's been married to for 20 years. Miss Talkenberry sent threatening letters and everything else to those people over there, including my daughter, my oldest daughter. She's done a lot of things. That's what made me push away. And had I known this was taking place, and I assure you that I would have tried to come and put up some defense because the evidence.
McKinney, you got the checks she was sending, but she's tried to serve you at least 8 different ways that I've written down, and you got none of this.
I didn't get anything.
When she was sending you money, you got it.
No,
when y'all were talking about having this business, you got it.
No,
but when
let me
he tried to serve you, none of this you got.
No, I did get the phone, the thing that she sent to the phone that she just described. That is the truth. I did get that, but by that time I had stopped communicating with her because of the threatening things that she was doing to my friends and That's the part she's not telling you. The evidence that I have to prove to you to prove that the money that she's talking.
No, sir, I
the
don't
money.
need that stuff until you can tell me about
Okay.
the service, because I'm still trying to
Okay.
track down how or when or where you might have been served. You're
Okay.
saying that you weren't served at 5946 Hohoman Avenue, and I have was Yolanda Yvette Bryant and
Yeah.
Latanya Bryant Miller.
Latanya Bryan is my oldest daughter. She's married and has her own house, and she lives in
And you said
South
that that's
Holland.
the person who helped you with your affairs because you're disabled?
That's my oldest, Latanya. That's what I'm telling you. I don't know how she found my oldest daughter. My oldest daughter lives in South Holland. She's married. She lives there. That's Latanya. LaShanya is one of my daughters, the one with the mental illness, but Muzi is the one that's my payee. That's the one that lives there too. I have two daughters that were living there at that time with their mother and three grandkids that live there with their grandmother.
Okay. So you're alleging after all of this that you never received notice except by text message.
Except her text message, when she would send like a check or something to that address, and I'm not getting into that because you said we can't, she would let me know that I sent it and I would go over there. It wasn't like I was living there. I would go over there and check the mail, and I kept telling her it's not there, it's not in the mail, because there were times when it didn't come. So I would kept going over there checking, because the apartment building was like this. All the mailboxes are like wide open downstairs by the door, and sometimes people coming in, they take mail and they do all that. So I would get there to make sure that I could maybe at the same time the mailman would come. So
all right.
it was.
So Mr. Tuckenberry, if I open default, then it's going to give you all an opportunity to do discovery in this case, which would elucidate for the court who was sending money for what the purpose of the money was, and whether the money that Ms. Tuckenberry claims she was defrauded of, whether there was actual fraud or whether this was some kind of romance thing gone wrong. And so what I'm going to do is take into account everything that she's filed, everything that you filed on the issue of whether default should be opened. If I do decide to grant the opening of default, then you would have an opportunity to do discovery prior to you all being heard again, either on a jury trial or a trial before me. Okay. So let me be clear. You've got a bunch of addresses. The one you presented to the court, you said you don't currently live at, and that is not your address. You said that. So what I want you to know is I'm sending my documents, my orders, anything that I have to the address you provided to the court. If you don't get them, we're on the record. That is not going to be an excuse for anything that you miss, because your addresses are floating. You got about 6 or 7 of them. And you just said you don't live at this address. This is a ex-wife and her current husband's address, but that's what you put on your paperwork. So if you're fine with that, I'm fine with it. But when I make my decision, everything is going to go to the address you provided. If you don't get it, you can't not come back and claim you didn't get something.
Yes, ma'am. That's fine with me.
We clear?
Yes, ma'am.
All right. So I'll make my decision on whether to open default. If so, I'll tell you how long you will have for discovery, and then I'll put you on a track for trial. Okay?
Thank you so much.
You're welcome. All right. So I believe that concludes the 10 a.m. calendar. Is that correct, Ms. Powell?
Yes, Judge.
All right. So the 11 a.m. calendar. Oh, right on. Oh boy. There we go. I'm sorry, Ms. Powell, I'm trying to find the 11 o'clock calendar that you sent, and I knew I just had it, but
I
not
can't
sure.
really see it, Judge.
I see the one where you sent the amended 10 a.m., but I don't see the 11 a.m.
Give me just 1 sec. I'm sending it.
Okay, thank you. All right, good morning, ladies and gentlemen. This is the courtroom 304, Clayton County State Court civil calendar for February 11th, 2025. I'm sorry, 2026. I'm Judge Tammy Long Hayward, and we are going to proceed with the call of the calendar.
Excuse me, Your Honor.
Yes, ma'am.
We can be excused.
Yes, ma'am.
Okay,
Ms.
thank
Tuckberry, you and
thank
Mr.
you.
McKinney will get my order in the mail, okay?
Okay, thank you.
All right, thank you. All right, so the first case on the calendar is Fizito Chansey versus Cedric Hudson.
Morning, Your Honor. This is Josh Samuels from Burrow & Associates on behalf of the plaintiff.
Okay. Anyone here on behalf of Cedric Hudson? Oh, Mr. Hudson is here.
Yes.
All right, so
Your
let me go
Honor,
ahead and call the calendar and see who's here, and then we'll come back to the cases, okay?
Your Honor, I'm sorry. I'm here on behalf of the defendant LLC.
Oh, the property rental company?
Yes, Your Honor.
Okay. Then LVNV funding versus charity grant.
Jasmine Shorter for plaintiff, Your Honor. Good morning.
Good morning. Anyone here on behalf of charity grant? Okay. Next is, this case has been removed from the calendar, so if there's anyone here, you're free to go. Gregory Fisher versus Joseph Jones and Palmetto Automatic, something that's off my calendar. But that case is going to be moved so that you're free to go on that. Krasinski Cameron versus ICER of Baywood LLC, First Communities Management. Anyone here on that case?
Good morning, Your Honor. Michael Woodard for the plaintiff.
Good morning. Anyone
Good morning,
here?
Your Honor. Sky Wellesley on behalf of First Communities.
Okay. All right. Next is First Portfolio.
Devin Arnold for ICER Baywood defendant on that one.
First Portfolio Ventures versus April Rose.
Morning, Judge. Matthew Tilden for plaintiff.
April Rose. Anyone here on behalf of April Rose? Next is Natalie Reese versus Kyle Codrington.
Good morning, Judge. Lauren Kaminsky on behalf of the plaintiff.
And Jason Deere here on behalf of the defendant, and we're the only two parties.
Yep.
Okay. And I believe this is the last case. This case, Charles Edward Bonner versus XYZ Corporation and Michelle Benson, a couple of Jane and John Doe's, and Placers Logistics. That case has been removed from the calendar. It's been continued.
And there's one more position.
Yes. Calvary SPV versus Tracy Holmes and Sandu Ministries.
Tracy Holmes here.
Okay. Anyone here from Calvary? Anyone here for Sandu Ministries?
I think they're on their way.
Okay. All right. So let's back to that. Fizito Chansey versus Cedric Hudson and Property Rental Company. Let's go ahead and hear that.
Okay, good morning, Your Honor. This is the date and time set for the damages hearing. I only have one witness, that's Mr. Chansey. I see him on the call today. I just want to give a brief opening statement because, as you know, the only issue today are the damages. Mr. Hudson is in default by way of an order striking his answer for failing to participate in discovery, and property rentals in default because they failed to file an answer for over 3 years. This is a dog attack case, so all elements of viciousness or negligence are deemed admitted. This is a case where 3 pit bulls attacked my client when he was walking past the property at issue, and he's going to give testimony today about how that impacted him. Mr. Chancey, are you there?
Yes.
Okay. Would you raise your right hand? Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. Mr. Chancey, I want to just talk about, let's go to the moment of the dog attack, and can you walk us through what you remember happening?
I was walking outside the backyard, going to the front. I was on my way to go shopping. And then on my left-hand side, the gate had a hole in it, and the dog had his head sticking out of it. Now, it shocked me because I thought it couldn't go through it. So then I kept walking, and then I turned my back, and then the dog came out barking. And then I thought it was going to go away, so I shoot it, and it didn't go away. And then it started barking. Then the other 2 dogs came out, and then all 3 of them ganged up on me. So one bit my leg, and then one tried to jump at my face, and one tried to jump at my hand, and I was fighting them off. And then I forced my way. One was like pulling me in my leg, trying to get a better grip. I climbed on the car to get away from them. Then they finally got off me and left. Then I got off and laid on the floor, and then people came out, and then they called the ambulance.
And were those 3 dogs, were they pit bulls?
Yeah, I think so. Yeah.
And you mentioned, go
Mr.
ahead.
Samuels, I know that's a big thing about people thinking pit bulls are vicious, but any dog can be vicious if they're not properly trained or raised. So the fact that it's a pit bull, quote unquote, doesn't really hold much weight with the court.
Understand, Judge.
Roman free can be vicious.
No, that wasn't what I was getting at, Your Honor, because any fault's admitted anyway, and viciousness is deemed admitted anyway. Laying foundation because we have some reports later that are going to be entered into evidence. And Your Honor, I'm about to display photos of the injuries. Is that okay to put up on the screen?
Well, I do tell you that we live stream. So if it is anything that is of an intimate nature that he would not want on the internet, then you might want to govern yourself that way. But otherwise, you put up your proof.
Okay, we have consent to do that. It's just it's the injury. That's all.
I got you.
Your Honor, we've submitted these exhibits to the court too. I'm going a little out of order, just for the court and for the record. This is going to be pre-marked as Exhibit 6. Mr. Chancey, let me know when you can see my screen. Okay.
Okay.
What am I showing here on screen?
It's my right leg.
And does this fairly and accurately depict the extent of the injury to your right leg as it was on the day of the attack?
Yes.
Okay. I'm also going to show you what we've pre-marked as Exhibit 7. Same question. What does this show?
The bite marks on my right leg.
And does it fairly and accurately depict those bite marks as they were on the day of the attack?
Yeah.
Your Honor, at this time, we move to admit the exhibits we pre-marked as Exhibit 6 and Exhibit 7.
It will be admitted. I guess Ms. Hune is here. You all are in default. You can challenge the damages as presented, but we're going to go ahead and let him put up his case. So 6 and 7 will be admitted.
Thank you, Your Honor. Mr. Chancey, you mentioned before that an ambulance came. What did they do for you?
They put me in a stretcher, and then they asked me questions about which hospital I wanted to go to, and am I injured anywhere else?
And Your Honor, oh, I'm sorry, I'm getting some feedback there. Your Honor, I'll display this on my screen. We have the ambulance records certified under the business records exception with the authentication statute reference. So at this time, we move to admit Exhibit 1, which is the ambulance report.
Okay, will be admitted.
Thank you. Mr. Chancey, what hospital did you end up at?
The Piedmont Health Center, I think.
Was that Piedmont Henry Hospital?
Yeah.
And what did they do for you there?
They had patched up my leg, gave me some shots, but they wanted to wait to see if they could get information on the dog, if I need like a tetanus shot or something like that. And then the doctor has stitched up my leg.
Did they do any scans at the hospital?
Yeah, they did some scans.
And Your Honor, Exhibit 2, which I'll put the certificate up on screen, is the same thing. It's certified under the business records exception. We move to admit Exhibit 2.
Will be admitted.
Thank you. Mr. Chansey, you had testified before that a doctor saw you. Was it a doctor that closed the wound for you?
Yeah.
I'm going to show you what we've pre-marked as Exhibit 3. Do you recognize this as the physician bill that you incurred in connection with your stay at Piedmont?
Yes, that is.
And it reflects charges of $2,244 for the physician portion of your treatment?
Yep.
Does this fairly and accurately depict that bill?
Yes, it does.
Your Honor, at this time, we move to admit Exhibit 3.
Exhibit 3 will be admitted.
Thank you. Mr. Chansey, I'm going to show you what we've pre-marked as Exhibit 4. You mentioned before that you had scans. Does this fairly and accurately depict the separate radiology bill you had for the radiologist that reviewed those scans?
Yes.
Your Honor, we move to admit Exhibit 4, the radiology bill from Piedmont Henry.
It will be admitted.
Thank
How much
you.
is the bill?
This one is $24, and in summation, Judge, I will itemize all these for you.
Gotcha.
Mr. Chansey, I'm going to show you what we pre-marked as Exhibit 5. What's shown here?
My right leg.
Does this accurately depict your leg as it was after it was bandaged at the hospital?
Yes.
Your Honor, at this time, we move to admit Exhibit 5 into the record.
Will be admitted.
Thank you. Mr. Chansey, can you talk to the judge first about the attack itself? And what I mean by that is, can you walk us through about what's going through your mind? Did you fear for your life? What did it feel like when this was all happening?
Well, yeah, I was afraid because I didn't expect 3 dogs to come out. There was nobody around. I was yelling, and there was nothing I could really do but like run or try to get on something high. And the cars was the only thing available like around me. So I was scared because it's like I never expected like to get attacked by dogs on the way to go shopping.
When with respect to the leg, because that looks like it's the worst of the 3 parts you mentioned, how many times were you bitten there?
So it grabbed my right ankle once and then grabbed it again the second time, and then another dog bit my inner thigh. So about 3 times.
In Your Honor, I'm going to display what we've pre-marked as Exhibit 8.
Yes.
I'm still going to have my client authenticate some photos, but on this one, we have a certification from Clayton County Police Department, and this comes in because it's something the department collected in terms of its investigation and has a duty to report. Scrolling down, though, before I move to admit, Mr. Chansey, there's 3 photos here. I'm just going to go through them real quickly. Just take a look at the first one, the next one, and the last one. Do these accurately depict the injuries to your inner thigh, your knee, and your leg?
Yeah.
Your Honor, at this time, we move to admit the report from Clayton County Police Department along with the attached photos as Exhibit 8.
Will be admitted.
Thank you.
And these were pictures taken on the scene when they respond with the first responders?
Yes, Your Honor. Mr. Chansey, we talked about the hospital suturing up the leg. After your discharge from the hospital, can you kind of give the judge an idea of what the recovery was like, what you were dealing with, and how this impacted your day-to-day?
Well, because I didn't expect this to happen, nobody came to help me, so I had to limp out the hospital. I couldn't get an Uber ride. I couldn't, no family, nobody to call, so I had to limp out and probably get to the bus. I threw up on the way there because they gave me some medication and stuff like that. And I couldn't work, but I had to work because I had stayed in the weekly. So I was afraid that if I didn't try to limp or eventually get to work, I'm going to lose the place where I'm staying at because that place was a weekly stay. So I went to try and work at the stadium and deep fry some food. It was hard to get there because it looked like I already had an issue, like I was disabled because I was walking, but I couldn't tell them, so I had to still try and work because of that. Because I didn't want to get kicked out where I was staying because I got bit by dogs. They wouldn't let me work if they knew I was injured already. So that was one of the things I went through, and I couldn't move anywhere and go back to family because they stayed too far. They stayed in a whole other state.
And you kind of touched on this, but at that time, is it fair to say you didn't have a car?
No, I didn't have a car.
How long after your initial stay at the hospital was it before the doctors removed the sutures?
A month.
How long was it before you were able to walk normally without limping or feeling any pain?
3 months.
As we sit here today, though, is it fair to say your leg is fine?
Yeah.
And there were no plans for any kind of future medical care?
No, I had to keep taking antibiotics. They gave me a prescription for like the first month.
Were there any concerns, Mr. Chancey, about rabies? Because were these dogs who were owned by somebody, or were they just randomly loose?
They were owned by somebody, but the people didn't know at the hospital whether or not they had any kind of like shots, if they been taking shots. So they gave me medication to keep taking just in case so I don't get an infection or something like that.
Is there anything else you want to add, Mr. Chancey, about your experience, how it makes you feel about dogs now, or how difficulties you had physically at the time the injuries were at their worst before we move on?
Well, I'm scared of like seeing more than one dog. One is fine, but like more than one dog, I get a little bit iffy about because I don't know if they might fight with each other or attack me.
Okay. You have scars?
Yeah.
And Mr. Chance, where do you have scars?
On the inside of my thigh and my right ankle.
All right, Your Honor, we pass the witness.
All right, Ms. Yin, and if I'm not pronouncing your name correctly, please correct me.
No, you're correct, Your Honor. I just wanted to clarify. My client did file an answer, and it was filed on the 24th of October. It looks like the complaint was filed on October 17th of 2022, and shortly thereafter, after they were served, they did file. It may not be, in the best form, but it looks like they did file. And
I'm sorry, say that again, because it sounded like you said the answer was filed before the complaint.
No, the answer was filed after the complaint.
So what date was the answer filed?
I have here October 24th, 2022.
Okay.
Your Honor.
And he filed an answer on behalf of whom?
One of the company's manager filed on behalf of the LLC.
So, Mr. Samuels, you want to respond to that?
I'm going to take counsel at their word. I haven't seen this answer in the 3 years the case has been pending, but things happen with dockets and whatnot. But assuming they're correct that an answer was filed, they have an Eccles problem. They need a lawyer filing that answer.
Yeah. Yeah, anytime in state court or superior court, if an answer is filed on behalf of a corporation, including LLCs and S corps, then it needs to have an attorney represent the corporation for the responsibilities of being a fiduciary and making sure that all interests are covered.
Yes, Your Honor. At the time when they filed it, they did it on their own. I was just recently retained, especially.
I got you, Ms. Yoon. I know you coming in on the tail end of this dog. Yeah. No pun intended. But.
Yes. Yes. So, in looking at the case, I didn't see any sort of default against the LLC. After they received the notice about the hearing today, that's when they retain, and that's why they are here. They take this case seriously. But after they filed that answer, they did not receive any further notices. They thought that the case somehow resolved. Based on their communication with Mr. Hudson, he's a tenant in this case, and he said that everything was taken care of until they received this notice.
Okay. All right, did you wish to ask Mr. Hudson any questions regarding the damages that he and Mr. Samuels are presenting here today?
No, Your Honor, we don't have any questions regarding the damages.
All right. All right, Mr. Samuels, did you have anything else to present to the court?
Just to make sure we keep the record clean, Judge, I just want to see if Mr. Hudson has any questions before we move on. He's a tenant, so he doesn't need a lawyer.
Yes, I do have a question. I don't, but I'm not sure if I'm really trying to make the right response. Do I question Chancey, or how do I ask the question? Do I ask Chancey a question about what he said as far as the dog bite, or
you may? He's a witness.
Okay. I would like to question him.
Okay, go ahead and ask your question, sir.
Mr. Chancey, when the one dog was out of the fence, approximately how far from the hole were you?
3 feet.
You were 3 feet away.
Yeah.
How do you, can you escalate, like how much of a distance it is from the time you seen the dog to the time that the dog attacked you?
The distance from the time I seen it attack me?
Yes. What was the time frame in between?
About 40 seconds or 30 seconds.
Did you at any time turn around and make any kind of hand gestures or jumps or anything at the dog?
Objection, relevance. This is damages, Your Honor.
Yeah, Mr. Hudson. So on this, because you all are in what we call default, meaning you have not actively participated in the case until this time, your questions generally are as to the damages that were suffered, not the actual underlying issue.
Okay, well, Judge, can we just so we don't have to go through the whole court process, I would just rather whatever your judgment be, I know it'll be in their favor, and just give me time to just pay it. I just don't want to keep going back and forth about it. I just rather go ahead and get away with it, and whatever you decide on their sides of the case, if whatever it is, I mean, I would just have to have time to pay it. I would make a monthly endorsement of probably $20-30 towards it, because that's all I can afford. I don't work for nobody at this time. I don't have a job, period. So whatever I could afford to pay them, that's what I would afford to pay them.
All right, Mr. Samuels.
Just brief summation, Judge, because I wanted to get you the amounts. All these bills are in the record right now, but the ambulance bill is $1,665. The facility bill for Piedmont is $4,914.46. The physician component, $2,244. The radiology component, $24. That's just to review the scans. The special damages, that's the economic loss, $8,847.46. Our ask today in total, economics plus non-economic damages, is $150,000. The basis for that, Your Honor, is, and I would caution the court on trying to tie the damages to the special damages here, because the treatment is, what you can do for a bite is to close the wound and clean it and do shots and make sure there's no infection. And I think we concede too that we're talking about a 3-month period of time where he's having difficulty walking. So it's a relatively short period of time. But I think the majority of the damages come from the visceral nature of being involved in an attack like this. And so having 3 dogs going at your legs, trying to go at your face as you're batting them away. You heard testimony about how he's trying to keep 3 different dogs away at the same time. Multiple bites in one area on the leg. You'll see the photographs again in the record on the worst injury, which I think is the leg. That's a visceral thing for someone to have to go through. And so I think that those non-economic portions are commensurate with that kind of attack, fearing for your life. And thankfully, this really wasn't, it could have been a lot worse, and it wasn't. And so you shouldn't hold it against Mr. Chancey that he was able to get away with minimal treatment. The attack is the attack, regardless of what happened afterward. And so for those reasons, that's why we're asking for a combined total of $150,000 plus court costs.
All right, Ms. Jim?
Yes, Your Honor, I just wanted to be clear. So my client, although they answered the complaint not through an attorney, but through the owner, but they denied in their answer all the allegations that were in the complaint. They also submitted a lease showing that in the lease that no pets were allowed on the property. Since that answer, no discovery were ever sent to the company, and nothing has been done. So I understand that today the hearing is about damages, but we ask that my client not be held liable for for the damages that the plaintiff incurred. They weren't aware of, in the lease, there were no dogs allowed on there. They weren't aware that dogs were on the property. They didn't know that the dangerous, I guess, proclivity of the dog, that the dog could bite. None of that they were aware of. They didn't know that the dog, I guess, slipped through the fence as alleged in the complaint. So none of this was something to their knowledge. They're here today because they received a notice. They just don't want to not attend after receiving a notice. But we ask that they not be liable. I have here my client, if she needs to testify regarding any knowledge, she's here to do it. But I understand that this is a damage hearing, Your Honor.
So we checked, Ms. Yun, and my staff attorney has confirmed that even though the answer was insufficient based on echoes, we did give notice to the corporate defendant at each stage of the proceedings. And so everything that we've done has also been sent to them at the address that we had based on the information that we had. So the same notice that they received to come to court today, all of the other pleadings that were filed and any decisions the court made would have been sent to that same address. And so I get that you're coming in at the last minute, and we don't, as a former defense attorney, civil defense attorney, we don't always get all of the information that is accurate from our clients. But yeah, just your representation that they were not kept aware is incorrect, because the court did continue to send notice to them, even though as a party to the case, even though that they had not actively participated.
Yes, Your Honor.
So, all right. So, Mr. Samuels, the non-economic damages, yeah, I can imagine that the attack must have been pretty terrifying for Mr. Chancey. I don't have a real problem with the amount of the economic damage, the non-economic damages versus the economic damages, because that's why I asked, does he still have scars? You talked about whether he still has a fear of, part of the consideration that we have is fear of injury, the fear that you had regarding the actual attack, and any future fear that's attendant to something that happens to you like that. So I don't have a problem granting the amount of $150,000 in this case, and if plus court costs. So if you go ahead and get me an order, we'll go ahead and do that.
I'll do that, Judge, and I just want to let the court know I also have to file a Rule 15 notice along with that proposed judgment, so I will get that on file at the same time.
Okay, thank you.
All right, thank you, Your Honor. Maybe be excused.
Yeah, Your Honor, I'm sorry, I have one last question.
Yes, ma'am.
So that order, is that against both defendants?
Yes, ma'am.
And but Your Honor, sorry, I know I'm here at the tail end of it, but I didn't see any sort of default in regards to the answer that was filed by my client. And I understand that there was a default against Mr. Hudson for, I guess he didn't participate, so the court has strike his answer, but I didn't see any sort of default against my client.
I will check again and make sure, but I'm pretty clear that I did.
Your Honor, if I could be heard on that,
yes, sir.
There's a difference between being in default and a default judgment. Today is the default judgment, but they are automatically in default by operation of not opening within the 45-day period. And just so I can, again, make sure, I know it's on, we don't have a court reporter today, but it's being recorded just in case down the line. If we want to construe my friend on the other side's argument as a motion to open default today, none of the 4 conditions plus paying costs have been met today anyway. So we have the Eccles issue, we have those conditions not being met. So there really isn't, with respect, Judge, discretion to open default at this juncture.
I do not. I lose that after the 45 days with none of those things having been done. So, all right. So we will proceed. I'll get orders out.
Thank you, Your Honor.
All right. You're free to go at this time.
And excuse me, Your Honor.
Yes.
Hey, Attorney Maharaj here. I was just wanted to make sure that a matter was called. I don't think I heard it. Was Wells Fargo Bank versus Quayshawn Ivy called?
I don't remember calling that. Miss Powell, is that on the calendar today? Or did I miss it?
I'm checking now, Judge. Attorney, could you would you just chat me the case number, please, just so I can check, double check? Thank you.
Am I free to go, Judge?
Yes, sir.
Thank you, ma'am.
So wait, before you go, sir.
Yes.
I'm a dog lover, but I'm a lover of dogs in a responsible way. And the way I mean that is dogs are wonderful if you care for them,
Yes.
but you need to train them. You need to secure them. Not everybody is a fan of dogs. And so I don't assume that my dog, because he doesn't bite me or he doesn't bite people that I'm close to, that he's cool with everybody. So what I say is dog ownership is an extreme responsibility. And I don't think we take it seriously enough. People want to have these big, mean dogs, which I own, I've owned pit bulls, and they are the sweetest dogs in the world. They're big old babies. But because people don't, the perception is that they're big, mean dogs, and people want to have them and put chains around them and do all of that crazy stuff when they're the sweetest dogs if they are raised right. But like I said, any dog can be a problem if not raised properly, and if not cared for properly, and if not trained properly, and if not secured properly. So Mr. Hudson, if you're going to be a dog owner, be a responsible dog owner.
I am, but I am, but like you said, this was a case where I didn't participate. I did have video footage. I turned it into the courts, but the attorney never got it. So I don't know. I wouldn't even know how to even go back and get the thumb drive from them. So, but now it's over with. Now I do take your advice and I do understand. I just want to let you know it was recorded. Of how the attack happened, but because I didn't know my rights and I didn't know how to participate in the case. The current case, because I didn't know how to participate, I didn't participate at all. So I can't blame nobody but myself for not participating, thinking that, okay, well, it's just like in a criminal case. In a criminal case, you go to court, you set up to go to trial, and then you go to trial, and then you can present the evidence at trial in the motion of discovery or make a motion. But me looking at it from that standpoint is different from this standpoint. So,
Mr. Hudson, you are so right. And I do my level best in these hearings because they're live streamed and I know people watch. Yes. I do my level best to do as much teaching as I possibly can, because I think a lot of people still aren't clear on the progression of a civil case.
Yes.
And how so hopefully as we do these hearings and people watch them, more people are made aware of, you can't just, like, once you get the paperwork, you can't just say it's going to take care of itself.
Yeah, that's how I looked at it as just like a regular civil case. Okay, if they set a trial date, we go to trial. I present whatever I gave.
Yeah, there's a lot more in between.
It's a big difference. Like I was looking at it even when I did the first thing that I did with the courts, and he was asking me questions, and I was thinking in my mind like, why am I gave the court all the evidence that I have. So why am I going to tell you any more things over the phone, over the line, or anything? So I just didn't communicate. So that's why I said, whatever the judgment is, I don't have a job at the time, however long it takes me to pay it. It just takes me to pay it. Just to get it over with. I don't want the property manager to be responsible for my responsibility. And I think what happened.
That's something that you talk to them about. But what I'm just saying is, like I said, I'm trying to do as much as I can to teach people through these hearings that there's more to it than just getting the paperwork and waiting for it to show up a calendar. Okay.
The first initial one got dropped in the other court, but then he came back and refiled it. That's what happened. That's how they missed it.
I got you.
That's how they missed it. But I understand. I got you. I appreciate it.
All right. Take care, sir.
Yeah, thank you.
All right, Mr. Maharaj, I'm sorry, I did miss that. So yeah, the case is Wells Fargo Bank. I guess I didn't go far enough down on the calendar. Wells Fargo Bank versus Quaisha Ivy.
She's here. I see
Okay.
her.
So I was on, next case was LVMV funding versus charity grant.
Yes, Your Honor. Jasmine Shorter for the plaintiff.
All right. Is charity grant present? Charity grant. All right, go ahead, ma'am, and present for LVMV funding.
Judge, Ms. Grant has been calling Chambers saying that she was having a hard time to get on Zoom. I walk her through it. I told her she may need to get on a computer, maybe not her phone, but she still haven't made it on.
When did she call?
Right at the 11 o'clock hour.
Okay, yeah, it's been 40 minutes. I'm still.
Yeah. And I went over it several times with her, but she's still not on. So I'm not sure. I'm just letting you know she did call Chambers saying that
okay.
She was not able to get
on. I'm present.
All right, so Ms. Grant.
Yeah, I'm here. Yes, ma'am.
All right, Ms. Shorter, go ahead and present on behalf of LVMV funding.
Yes, Judge.
Ms. Grant, I'm going to need you to turn your camera on if you're going to participate for me, okay?
Oh, it's on. It's saying that it's on.
There you are. Okay.
Yes, ma'am.
Thank you.
Yes, ma'am.
All right. So this is 2024 CV 013 with 01039. Go ahead.
Yes, Judge. We're here today on plaintiff's motion for summary judgment. Plaintiff has filed his business records affidavit. Additionally, Your Honor, we served the defendant's counsel at the time with discovery back in September of 2025. Specifically, we served them request for admissions. Defendant nor defendant's counsel ever responded to the request for admissions, Judge. And it's longstanding that failure to respond to discovery, particularly requests for admissions, will deem all of those admissions as admitted. Furthermore, Judge, after the court extended the time for a defendant to respond to plaintiff's motion for summary judgment, no response was ever filed in opposition to that motion. Furthermore, Your Honor, the defendant's answer does admit that the defendant applied for and received the loan, and admits that the defendant was required to make payments and that she breached the agreement by failing to make the payments, Your Honor. Excuse me. Based on the foregoing and defendant's motion and the record, there are no material issues of fact in this case, and plaintiff requests that the court enter summary judgment in its favor for $17,915.69 plus court cost of $320.89, Your Honor.
All right, Ms. Grant. So there's three ways that Ms. Shorter is saying that you failed to present an issue for the court to determine that you don't own the loan. So the request for it, I understand that you had you had counsel who withdrew earlier in the process, so we dealt with that. But that she sent requests for admissions that have to be answered and returned under oath within a certain amount of time. It's not a short amount of time, but a certain amount of time. Those requests for admissions were not responded to. And so everything that she asked was deemed as taken to be true because they were not refuted. So that was one. Number two is that in the motion for summary judgment, she's taking into account the request for admissions and the answer that you filed where you would acknowledge that you did take out the loan, that you did incur the debt, and that you did fail to make payments. And so based on all of those things, she's asking the court to grant the amount that is outstanding of $17,915.69 plus the court cost of $320.89, I believe what I wrote down. Did you have any questions at this time?
No, I don't have the money to pay them back, but no questions. I mean, I got to get it to them the way I can. So yeah, but no question. Everything she said is true. Yeah.
Okay. So Ms. Shorter, is there a mechanism by which she can contact your client in order to post judgment, set up a payment plan maybe that would make sure that you all are in communication about the debt?
Yes, Judge, she can reach out to our office. Any of our collectors in office would be able to assist her.
Okay, do you have is there something that you can chat to her?
Yes, put our
Okay.
office number in the chat, Judge.
All right, so Miss Grant, she's gonna send you a chat. You should see a red box with a white number in it. And write that down so that you can communicate with them, because it might just be easier than to have them go through all of the means that they can, which might be, you know, you kind of want to control the process as much as possible if you can. Okay.
Okay. Thank you, Jasmine. Thank you, Judge.
All right, Ms. Grant. All right, so Ms. Shorter, court is going to go ahead and grant summary judgment in this case, and then grant the amount of $17,915.69 plus $320.89 in court costs. And hopefully your client and Ms. Grant will be able to work out something that's amenable to both parties.
Okay. Thank you, Judge. Thank you, Jasmine.
Take
All right.
care.
Thank you, Judge. That's all my business with the court this morning. May I be excused?
Yes, ma'am. All right. So
Good morning, Your Honor. I'm sorry. This is Attorney Mika Crawford Franklin. I am here on the Wells Fargo versus Miss Quayshawn Ivy, but I'm here for the coverage attorney. I'm coverage for attorney, excuse me, Sade Clark, but she had filed a motion to withdraw, and so my appearance is kind of limited, I guess, based on the court granting it because it hasn't been granted. But Miss Ivy is aware of it and consented to it. And so I wanted to see if the court would be willing to hear that matter first, because Miss Ivy is going to be just representing herself today. So I didn't have to stay on for the whole matter.
All right, Miss Ivy, did you were you aware? Hold on a second. Let me just go ahead and call the case.
Yes, ma'am.
And let's get this taken care of in the
Thank you.
All right. So this is case 2025 CV00620 Wells Fargo Bank versus Quaysha WN Ivy. Miss Ivy, is it Quayshawn?
Yes, ma'am.
I think there's a space.
Yes, Your Honor.
The SHA and the WN. I apologize. I did not mean to.
Quayshawn.
It's just the way I'm reading it, that's the way it's coming across on our calendar. Raise your right hand for me.
She said it, Your Honor. It's just really soft.
I'm sorry, Mr. Maharaj.
She did say it. Her voice is just very soft.
Oh, okay. So you're gonna have to speak up for me a little bit, Miss Ivy, and raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am. Yes, Your
All
Honor.
right, you can put your hand down. So you're before the court on a couple of things that are pending. Your attorney sent in a motion for withdrawal because it is my understanding that she's saying that you all have come to a parting of the ways, and she wants to withdraw as your attorney of record. Were you aware of that?
Yes, Your Honor. I was a part of I was doing a debt consolidation, and I had lost my job and fell behind on a lot of bills in the past couple years. So
okay, not the debt. What I'm saying is, did you know that your attorney wants to not represent you anymore?
Yes, ma'am.
Okay, were you aware of that?
Yes, Your Honor.
Did you have any objections to it?
I mean, no.
Okay. So you understand that once she stops representing you, you're responsible. So if the court, if something happens in the court and this case continues beyond today, you would be responsible for making sure that you answer anything that needs to be answered either from the other side or from the court. You understand that?
Yes, Your Honor.
All right. All right. So Ms. Crawford Franklin, I'll go ahead and grant the motion to withdraw.
Thank you, Your Honor.
All right. You all are done at this point. You're free to go. I'm sorry.
Yeah, there is a motion. Plaintiff does have a motion for summary judgment that was filed on April. Would be possible?
Mr. Maharaj, I got that. What I'm saying is I'm letting her go so that we can get to the substance.
My apologies, Your Honor. I'm sorry.
Thank you, Your Honor.
All right. Thank you.
Okay.
So this is Wells Fargo versus Quayshawn Ivy. All right, so Mr. Maharaj, go ahead and present on behalf of Wells Fargo.
Yes, Your Honor. We are, as mentioned before, we are just here on plaintiff's motion for summary judgment. This is just to give a brief summary of the matter. This is concerning a credit card agreement entered into between Wells Fargo Bank and Quayshawn Ivy. There is a default on that account, which is the subject of this lawsuit. Although defendant has filed an answer, it is plaintiff's position per the motion that they have not met their burden to show that there are any true issues of fact in this case. So therefore, at this time, plaintiff asks for summary judgment in the amount of $6,918.13 as an outstanding balance, and $307.11 in court costs, and attorney's fees in the amount of $716.81.
All right. So, Ms. Ivy, so this is what we have. What Mr. Maharaj is arguing is that even though there was an answer in the case, it didn't present issues that the court can consider to determine that there's a possibility you didn't owe the debt or a defense against the debt. Is my understanding from what you previously said that you may have incurred the debt and then had hard times where you maybe had a job issue or were not able to pay at that time. Did you want to speak to what Mr. Maharaj has presented?
Yes, Your Honor, if I may.
You may.
So going back to that, the story behind everything, I did do a debt consolidation with my previous attorney, Ms. Clark. I incurred hard times, lost my job, and incurred a bunch of grief behind all that, and I wasn't able to keep up with my payments to ensure that Wells Fargo was being paid through that debt consolidation. There was an agreement around middle of last year where they set up a payment plan, and I agreed to it at the time because I thought I would have I would be working, and that did not happen. So I was not able to uphold that agreement. But I'm asking if there's some type of agreement that could we go through with that right now, because I'm still experiencing hard times, and it's going to be very hard for me to retain the payments that are on my home versus, all the other payments that I've fallen behind on. And then on top of that, be able to pay back this debt that I owe Wells Fargo. So I just want to see if we can come to some type of mutual agreement in this case to be able to help me help you all get your funds back.
Okay. So, Mr. Ivy, this is what I say to anyone in this situation. I'm not able to dismiss the case or not go forward on the case per the information that Mr. Maharaj's client has presented, because I have to be balanced and fair in what I do. And as much as I understand you have a hardship, they also have a legal right to have the debt repaid, and they've done what they're supposed to do to pursue that. But what I do say is, once I have granted the judgment in this case, Mr. Maharaj is going to present you with information from his client that would allow you to speak with them about possibly setting up a payment plan, and then maybe managing how they collect the debt from you, as opposed to a possible garnishment or something else that might be harsher consequences on you while you're trying to work your way out of this situation. And Ms. Ivy, every day is a new day to be better and do better and have better. And so I say, don't ever despair that you're not going to work your way out of this situation, because every day is an opportunity to take a chance on something else. Like, you might find a new job. You may get a job and a side hustle. Like, you figure out something you can do that is helpful to you, that you enjoy, and then you might be able to monetize that. So these are all things that can improve over time. So I just say, don't despair. But Mr. Maharaj, if you would chat to her the information that she needs and the person that she needs to speak to maybe set out a payment plan or figure out a way to work through the collection of the debt. Is that okay, Ms. Ivy?
Yes, ma'am. Thank you, Your Honor.
But I want you to remember that everybody has hard times from time to time. It's not just you. Don't bear shame on that, because everybody in America, 99.99999% of the people in America have debt. And a bunch of us have trouble managing it all. But what I say to you is, don't despair. Keep looking for those opportunities to take that step up, okay?
Yes, Your Honor. Thank you.
All right, so Mr. Maharaj, I'm going to go ahead and grant the motion for summary judgment in this case for the amounts that were listed. You have presented the court with an order, and so we'll go ahead and get that order signed. We'll get a copy of it out to you and to Miss Ivy. And Miss Ivy, if you will write down the information he's chatted to you, so that you can contact those individuals and maybe get this process underway, okay?
And also, Miss Ivy, if you could provide me also with a good email address and phone number, so that we can just put this on your records in case we need to reach out to you, that would also be very helpful.
Yeah,
Yes,
so
sir.
when he sends you to chat, just go ahead and respond to him, and then we'll be able to get that done.
Yes, Your Honor.
All right. Okay, well, take care, Ms. Ivy, and once you are finished exchanging information, you and Mr. Maharaj may be excused, okay?
Yes, ma'am. Thank you.
You are welcome. All right, where was Krasinski Cameron versus Iser of Baywood versus First Communities Management.
Good morning, Your Honor. Michael Woodard for the plaintiff, Krasinski Cameron.
Good morning, Your Honor. Sky Wellesley here on behalf of First Communities. And I believe there are Ms. Floyd and Ms. Lewis are on the list here. I'm not sure if Mr. Woodard intends to call them or needs them here, but my understanding from a recent conversation was they were accidentally served with the notice of this hearing. I don't think they need to be here, and so unless Mr. Woodard thinks otherwise, maybe I'll let them go.
No, Your Honor. I think the court, when it sent the notice of the hearing out, the clerk may have sent the notice to some of the witnesses in the case. So I have no. I mean, they can stay if they want. It's a public hearing, but
Is that Floyd, Lewis, and Lyons?
Diamond Lewis and Ketra Floyd, I believe, and I believe there's also a defense attorney here for the other defendant, Mr. Devin Arnold.
Okay, because yeah, I'm not sure who all they sent to. Sometimes whoever's on the notice for what's the electronic filing? Peach Care. We don't have Peach. We have the other one. Yes, if it's in CPU Odyssey, they send it to whoever's in there. Okay, so this is a premises liability case, my understanding, and the defendants are corporations, either management or owners of the property.
Yes, Your Honor.
All right, and this is the we're talking about I guess bifurcation.
Yes, Judge.
Okay.
Yes, Your Honor, we filed a demand for bifurcation that was joined by the co-defendant Iser of Baywood. And in response to our demand for bifurcation, plaintiff filed an objection, I guess, and a response, which we filed our reply yesterday. But the long story short is the way the new tort reform statute is set up is that it doesn't give the court, frankly, this may short circuit some of the arguments, a lot of discretion as to whether or not bifurcation is allowed, and that's why it's a demand for bifurcation. Under the statute, the only way the court can not allow for bifurcation is if it involves a claim for under, I think it's $150,000, or a claim for sexual abuse or something like that, which neither one of those circumstances exist here. So while I understand Mr. Woodard would like to have his objection on the record, which he has preserved, I'm not sure the court really has discretion to not bifurcate, frankly.
That is my understanding, and that's the hot topic among judges who are now faced with trying some of these cases. So yeah, it was my understanding that if the threshold is met monetarily, or like you said, the other exceptions aren't apparent, then we would have to do the bifurcation. So, all right, that was a short and sweet argument. Go ahead, whoever wants to respond.
So, Your Honor, Mr. In terms of my objection, if I could put on, explain it to the court. Essentially, the tort reform statute enacted 51-12-15, which gives the defendant or any party the option of demanding bifurcation. The problem with the statute, because it's very poorly written when it was rushed through. Oh, can you hear me?
I said I was whispering that there are many problems with the statute.
Yeah, yes, Judge. And so the primary problem that I have with it is it creates a due process violation because it, in one sentence, says that there has to be two multiple phases of trial, and then it points to the old statute on bifurcation 9/11/42, but it does not handle how the new law is going to address things like causation, because the new law is requiring that there are apportionment of damages in the first phase, which would traditionally be the liability phase.
Mm-hmm.
So now it's something else. It's liability and apportionment. The only way that a jury can apportion damages is if they are presented evidence of those damages. Because the jury cannot determine what damages are related in this new first phase unless they're presented evidence of these damages. I anticipate that when we go to trial, and perhaps we're putting the cart before the horse in terms of the procedure here, but I anticipate when we go to trial, I will get an objection when I try to put in evidence that, for example, Mr. Cameron is paralyzed because of the shooting. And they're going to say, oh, no, this is phase 2 evidence. This can't come in phase 1. The problem is I have to, under this new statute, I have to apportion, there's an apportionment of damages. So there has to be evidence of the damages that need to get apportioned. There has to be causation evidence. I have to be able to put on doctors to say, this injury caused his paralysis. And so then we get into sort of the other problem on the apportionment, because what the new statute says is in phase 1, after there is a determination of apportionment, then it points to 51-12-33, which talks about how the damages are apportioned. In 51-12-33, subsections A and B do not apply under the reading of the new law. And so since the defendants have elected to do these two or multiple different phases under the new law, you cannot read the old apportionment statute in conjunction with the new apportionment or the new bifurcation statute and have an apportionment of damages in the second phase. So we're left with essentially A and B of section 51-12-33 not applying in this new damages phase that the defendant have elected, and only subsections C and D for the jury to determine. And so that creates a lot of issues. And so my objection is not necessarily to the defendant's ability to demand multiple phases under the new law. My objection is that if we go that route, then there's a path, and that path is going to require, number one, evidence of some damages and causation in the first phase of the trial, and then an election that there should not be apportionment between the defendants in the new second phase. It's essentially changing how the phases are defined, would be how I'm looking at it. So it's not a traditional liability phase, then damages phase. Now it's liability and some damages, and then and in the second phase would be evidence, for example, of the amount of non-economic damages or the amount of the damages vis-a-vis medical bills or future medical care. that would come in the second phase under the new statute, but not in the first phase. In the first phase of the new statute, we would still have to prove causation. We would still have to prove some damages, not necessarily the amount of the damages. So in order for the jury to make its determination of apportionment. I also have an objection because, and you know, I wrote in my my brief, Your Honor, there's a question of whether the new statute, this is subsection 4, whether the new 51-12-15 applies even at all in this case, because this is a case that was filed before the tort reform bill was passed. And so this cause of action was not pending before it was actually filed. And so essentially
that, not to interrupt you, but I think the way that I think the judges have considered this argument is that if the pretrial order is filed after the tort reform, after the new tort reform phase versus before, then if the pretrial order was signed before, then it travels under the old path. But if it was signed afterwards, then we're going down the tort reform path. That's what I've been hearing. Now, I'm gonna be honest with y'all, I haven't tried a bifurcation yet because everything I get settles for some reason. And when I get a case that's going to civil trial, I mean, it's like every time I set a civil trial calendar, people are diving off the bridge like there's gold in the water. So I haven't had to do this yet, even though there's been a lot of traffic. The arguments that you're making, Mr. Woodard, are heard. And Mr. Wellesley, there's, like I said, judges we're daily talking about these things and trying to suss out what comes in the first phase versus what comes in the second phase. It is hard to control because if you have to show that there is some damage done in order to move to the second phase, but you can't say how much damage because you're going to get into how much, we're going to get into like compensation for the damage done, it becomes very, very difficult. Now, the statute is not written well. The problem we have here is that nobody has challenged it such that we have the appellate court looking at it to interpret for us what's going on. We don't have a lot of direction with respect to how judges are supposed to do this. And so we're all kind of collaborating with each other in an attempt to get it right, but knowing that there's a possibility that exists that we'll get it wrong because we don't have a lot of direction. And I'm just going to be honest. Not enough lawyers run for the legislature, and not enough trial lawyers run for legislature, because when you are a trial lawyer, you know the limitations of what happens when we come up with something new like this. Just like when they came up with 9/11/64, and now we're talking about different ways to determine how much money is awarded in attorney's fees based on the inability to settle and at the settlement phase. In fact, I think I got that right, 64. So we get all of these new rules, and we're supposed to figure out how to move them forward when we have no guidance and we have people who don't do trial work making these rules. And so I completely get it, Mr. Woodard. The most I can tell y'all both is that I'm gonna do the best I know how, and I'm gonna consult with other judges to see best practices. But I can't guarantee you that there's not gonna be some sticky wickets that we're gonna have to work through at trial. I don't know that I can refuse Mr. Wellesley a trial by bifurcation based on any of the arguments you've made, just because I really don't believe I have the ability. Just because the law is bad, I don't have the ability written into the law to use my discretion to say, I'm not doing this because the law is bad.
And I understand that, Judge. And I think my point is because the law is poorly written and it is bad and ambiguous in terms of how it's supposed to be interpreted, it's unconstitutional and it violates my client's due process. And when a law is unconstitutional and it violates due process, that law should not be applied. And so the court does have within its discretion the ability to find the law is unconstitutional and violates my client's due process, and therefore it should not be applied in this case.
All right. All right, Mr. Wellesley.
Yes, Your Honor, thank you. I guess I'll just start with we act like this is such a novel concept, but trial courts have been bifurcating trials for decades, and there's never been an issue presented like this, and no court that I'm aware of has ever said that bifurcation in and of itself, even though we've been doing it for decades, is in any way, shape, or form unconstitutional. This has only become an issue because the plaintiff's bar doesn't like the ability to demand bifurcation because it allows us to talk about what the defense is supposed to talk about and keeps the jury focused on the issues, which in this case is going to be liability. And then depending on what those issues or how those issues are addressed, we'll move on to the second phase. But we're not, what the legislature did was it tried to separate these issues of unfair prejudice against the defense by requiring that the liability parts of this determination are made before all the sympathy parts come in, with relates to the severity of the injuries and the damages.
I
And
get that
the
that's the
legislature,
argument. That's the talking point, Mr. Wellesley. Let's just be honest. And I get that the defense bar is head up over heels about this. But not because it's good law, but because it complicates it such that it tends to weigh in your favor. Bifurcation before or apportionment, any of those things, and I've done cases under the old path. What I say is liability is almost inextricably combined with what damages that liability caused. And so when you start talking about liability and somebody was shot, and in this case, it's premises liability, somebody was shot. I've done that case before, trust me. I'm not new. Went all the way through trial on a case like that. So when it comes to that, but when you're talking about the hamstringing the plaintiffs from saying, hey, he was shot by this unknown actor, and then they can't say, and he was paralyzed, because that might give sympathy for the jury to decide, well, now we can go on to the next phase and then consider damages. And so that's where judges are having trouble, is because it's not that we begrudge you the ability to bifurcate. Under the old system, it was fine. I didn't have a problem with it. What the issue is that where do I draw the line between y'all saying the jury's going to have sympathy if you mention that he can no longer walk because he was shot, as opposed to like, what do they say? Well, he was walking fine until he got shot 5 times, and now he doesn't seem to walk as well.
I think the issue there is we're confusing fault and causation. And the way the statute is addressed, and we've been dealing with this issue in Georgia for decades. This is nothing new. The apportionment of fault, and the reason it is called that is it's allowed for the various defendants to have their specific fault determined prior to we get into the damages. Now, the nice thing about this case, and we're talking in very broad terms, it's kind of about theory here, but as it specifically relates to this case, this is not a case with muddled causation arguments, all right? This is not an automobile accident where there may have been pre-existing conditions or whatever. There was a shooting and there was a paralyzation after the fact. As a result, this is a very straightforward bifurcated trial because, again, we're not talking, and I understand that there may be some gray area if we were talking about a case where, you know, there was not relatively an objective injury of a shooting and the paralyzation that occurred after the fact. That's not what we're talking about here. What we're talking about here is the apportionment of faults, not necessarily causation, which is why, to address Mr. Woodard's point earlier, this is a very easy and good one to address these issues because, again, it's a apportionment of fault. We're asking the jury to apportion fault as it relates to liability, not necessarily delve into the causation issues, which would lead into the damages issues. This is very much a black and white liability argument, liability section, results in a shooting, results in, and that's what we're here to talk about in phase one. And then in phase two, he's paralyzed, he requires medical treatment or whatever. And so this one is a very much a black and white case where bifurcation stands very well to move forward in that regard. And as it relates to the apportionment issue, generally, we've been dealing with this for a very long time in Georgia, and it's never been raised as an issue. Juries determine fault all the time, and they apportion fault all the time. That doesn't necessarily mean they are responsible for any amount of damages, which, you can do in phase one. What non-party, what other individual may be at fault for the accident, jury makes that determination, and then we get those numbers, and then we can move on to phase two, where we apply the numbers they award in damages to the percentages of fault. It's a very straightforward system that has worked well here. And as far as I know, there's been no law at any point in time, again, either challenging the bifurcation or the apportionment issues as they would be presented here.
Mr. Woodard? So what I suspect is Mr. Woodard wants me to be the judge that sticks my foot out there and says this is unconstitutional. And then I get to be the test case with a very unblemished appellate record. I'd like for y'all to know that I have been affirmed on magistrate court as a sitting superior court judge and as a state court judge. And I don't think I've ever lost an appeal. Not that, that's just a little bit of shoulder brushing, but not that I care one way or the other. If the law ends up being right in the end, if I get overturned, I don't care. The problem is that I got to look at the issues to see if I feel like if it is just a poorly written statute, or if the statute does implicate constitutional issues that would take away due process from the plaintiffs in this case. I get what Mr. Wellesley is saying, and this might be that rare case where it is easy to separate damages from fault and causation. Who shot this guy? Well, they did. We didn't have anything to do with him being shot. Okay, well, let's go to the next phase. Well, we just say that they have the premises has no responsibility for this. The unknown shooter has all of or 80% of the responsibility for this. And at that point, Mr. Wellesley said, we don't even have to deal with whether he's, paralyzed or not, because that's not their problem. And he says, this is the case to do that. So
what I would say, Judge, is I don't think that I think that if you overturn and determine that this statute is unconstitutional for due process violations, I think you would be affirmed on appeal. So your record will be the same.
That's what you think. I think that a lot of people would be watching it because I think a lot of people are dissatisfied with it. And even from the standpoint of the defense bar, I don't know that it does everything that we sort of intended, or it was sort of intended to do.
And I think that's my point, Judge, because if this new statute were to say that the defendant can elect to bifurcate the trial, and if they do that, with the exception of the 150,000 or the sexual assaults, then and point directly to the apportionment, 9/11/42, that would be one thing, and that would not have the same issues. But here, what the legislature did is they changed how the bifurcation process of what goes into each phase. And so Mr. Wellesley is saying, we've done this for 20 years, 30 years, there isn't an issue. That's under the old law. Under the new law, it specifically says the trier of fact shall, in the first phase, which is not called a liability phase, it just says in the first phase, the trier of fact shall determine the fault for each defendant, and if the trier of fact finds that any defendant is at fault for the plaintiff's injuries or wrongful death, the trier of fact shall further determine the appropriate form of the verdict, the percentages of fault for all persons or entities that contributed to such injuries. How can I put on the injuries in the first phase without talking about the injuries. It's
Yeah, Mr. Wellesley.
incompatible. And so
because if they say he's at fault for shooting him, and then the statute says who's responsible for the injuries, well, there have been people who've gotten shot and had very few injuries. They got a scar because they got a flesh wound. So when does he get to tell the jury that this man was injured, so that there were actual injuries caused?
So and what I would submit to the court, Judge, is under the new statute, if it were to apply, it's not a liability phase one. It is a phase one that is liability, causation, and apportionment. And then in phase two, which is not which would be similar to the old damages phase. In phase two, that's when the evidence comes in from, for example, his brother or mother, and say, this is how this injury has affected him.
Yeah, the non-economic damages. Yeah.
Correct.
But where do the economic damages come in, Mr. Wellesley? So let's say he was in ICU, he had a huge medical bill as a result of being shot. What phase does that come in?
That would all go to damages, Your Honor. That'd all be phase two.
So the jury comes in and they say, this man is walking across the premises, an unknown actor comes out of the shadows and shoots him 5 times. Who do you think is responsible? That's all we get in phase one, is what you're telling me.
That's correct, Your Honor. That's the way the statute works.
And so a jury who's wondering, well, what happened to the guy? Did he just get shot? Well, was he killed? Do we even know that he's still alive? But other than him sitting at the table, do they get to say, hey, he is here?
I will say, Judge, that, with this one in particular, I mean, Mr. Cameron is in a wheelchair. I mean, he's going to be participating in phase one of the trial. And so, I guess what we're saying here is, and we're putting the cart before the horse. I mean, there's a lot to come in this case. We haven't even filed summary judgment motions yet. We haven't entered a pretrial order yet. I mean, there's a lot. Frankly, we're talking about this, which is something that should be dealt with at the pretrial conference, and we kind of put the cart before the horse here. But yes, Your Honor, there will be. Yes, I understand that the damages part of this, that he was shot, that he became a paraplegic, all of that would be in phase two and phase one, because it would be, yes, he got shot. This was the shooting that occurred. The facts are surrounding the actual incident. But when it talks about, like what Mr. Woodard just brought up, bringing his mom in to talk about what happened, how it affects him now, as Your Honor brought up, the medical bills, the ICU stays, anything along those lines, those would all be in phase two. Phase one would strictly be about the incident, the shooting, and who's at fault for the shooting, and the jury making an apportionment related to the fault for the shooting. The damages part, as it relates to damages, the medical bills, the future impact, all those types of things, those would all, as it's designed by the statute, be in phase two.
And so what I would just clarify my position as opposed to Mr. Wellesley's is, in phase one, there will also be evidence of medical causation. Okay. And to expound upon that, the doctors are going to get to say he was shot, the shooting caused him to be paralyzed, right? And these are the diagnoses that he has that are related. So for example, in this case, after he's paralyzed, he's diagnosed with something called he's got an autoimmune disorder where, because of his paralysis, he suffers it's autoimmune or automatrophic dysphoria. I'm butchering that, but because of his paralysis,
phantom limb syndrome.
No, Your Honor. Basically, what happens is, because he has lost all feeling below his legs, he can't urinate on his own. And so when his bladder gets full, he can't feel it. And eventually it gets so full that it kind of takes over his mind. He gets terrible headaches, and he doesn't know what's going on. He ends up in the emergency room, and then they have to do other things. And because of his paralysis, he's developed pressure ulcers that are very serious. And so he has all these other things. Those all go to the injuries that he suffered.
So Mr. Wellesley, I honestly believe that this needs to be sussed out before we get to the pretrial order. The last apportionment case I did, are you frozen?
No,
Okay.
Your Honor, I'm sorry.
The last apportionment case I did had, which was premises liability, person got shot on the premises. We had like a whole week of motions in limine and arguments about motions in limine. And that was with understanding the old apportionment system. So with this being the case, I don't want us to get before a jury and then y'all are arguing about whether we can say this or not say that. So at some point, we're going to have these check-ins periodically. If you want to bifurcate, I'm fine with it, but we're going to check in, because what I don't want is Mr. Woodard preparing his case and y'all saying it ends at the police report where we talk about he was shot, he was laying on the ground, the police came, he was taken to the emergency room, boom, that's all we hear. And now y'all determine who's at fault for that. As opposed to Mr. Woodard saying, well, at fault has to include what happened to him, like who's at fault for what happened to him, meaning the at least the economic damages that he suffered or the injuries he suffered. Because damages, the injuries he suffered, and you're saying, no, we just want it right at the police report. As soon as he is taken off the ground and taken to the hospital, that's where we stop this case. And I don't know that that's the case.
Well, Your Honor, I would like to correct one thing that Mr. Woodard said. Mr. Woodard said that causation is included in phase one. That's not my understanding of it. Causation of the injury itself and the injury that would develop would all be a phase two type thing. Phase one, as the statute is as written, as the legislature passed, and as the law of Georgia says, that we are to address liability arguments and fault in phase one.
Okay, when define fault for me, because it's just like the way lawyers speak and the way legislators speak and the way normal people speak, it's a different thing. We can have three different definitions. Tell me in this context what fault means.
Fault, Your Honor, in this context would mean responsibility for the accident itself, not the injuries.
It wasn't an accident though.
Sorry, the incident, the shooting, yes, everything up to the actual injuries allegedly sustained in the accident. This would be, the allegations in plaintiff's complaint regarding the liability, the negligent security aspects of it, and or the shooting itself.
Okay, so fault is merely a determination of who did the bad act.
Yes, Your Honor. Who's at fault?
The problem is in a premises liability case, the determination is not merely who shot, but also whether someone could have prevented the shooting. And so where does that come in?
Sure. That would all be phase one, Your Honor. So contributory negligence, third-party fault, all those things would all be phase one, up until we start talking about the injuries themselves, the causation aspects of the injuries, and the damages arising therefrom. That would all be phase two. Phase one, again, would be about fault, which would be the things we just talked about, the things in the plaintiff's complaint related to liability, the alleged negligent security, the shooting itself, contributory negligence, apportionment issues, those types of things. But it would not get into causation, and it would not get into damages, which fortunately, I understand in some cases there may be a more muddied ground there regarding causation of injuries, but in this one, it's a pretty black and white, again, determination of, there was a shooting and then those caused injuries. And so it's a much more straightforward analysis in this particular case.
Okay. Anything else, Mr. Woodard?
Your Honor, I would say that there are two definitions of fault. There's a definition under the old statute, under the apportionment statute, and then there's a definition under the new statute. And if I can share my screen, I can show you, Your Honor. This is the new statute, and I'm on Westlaw. And it says in the first phase, the trier of fact finds any defendant is at fault for the plaintiff's injuries, which is specifically defined in the new statute in phase one. Then the trier of fact shall further determine through the appropriate form of the verdict the percentages of fault for all the persons or entities that contributed to such injuries. What Mr. Wellesley is saying is, no, you don't get to talk about the injuries in phase one because traditionally in the old statute, that would all be the second phase. Under the new statute, that's not how the legislator wrote it. They wrote it to put the injuries in phase one. The amount that the jury determines for the damages vis-a-vis the amount of the medical bills, the amount of the pain and suffering past and future, that's the evidence that goes in phase two. But what the actual injuries are and whether those injuries are causally related to the shooting come in phase one under the new statute.
Yeah, Mr. Wellesley, damages and injuries are separate determinations. Somebody can be injured, but the damages attended to that injury are separate. So that's a separate determination. So when they say injuries come in and you're saying we stop at the police report, I find that a little bit discordant.
Well, fault for the injuries is different than causation. If the legislature had meant causation in phase one, they would have said the word causation in there.
No, that's not what I'm talking about. You said fault for the injuries. That's what the statute says. But how can we determine fault for the injuries without determining what the injuries are? As you said, the whole point of the statute is such that it doesn't become a sympathy battle at the front of the case. But if we can't talk about the fact that he was shot, those shots resulted in him having an injury to his back, an injury to his spleen, an injury to his spine, then those injuries further caused him to be in a wheelchair. But we just gonna, like, where does where do we put the injuries? Like injuries, like I'm shot. Okay, that's one injury. The bullet went through my spleen. That's an injury. The bullet grazed my spine. That's an injury. Are we going to lay all those out, but we're not going to say he's paralyzed? I just don't get how you bifurcate, like how you separate all of these things. And I'm putting a lot of pressure on you because you're having to answer for the flawed statute. But what I'm asking you to do is to contemplate. I hate messy trials. I hate when we get to trial and we still have not figured out what goes where when. And people will tell you that I'm not known for messy trials. If you ask about all of my civil trials, I'm not known for messy trials. So I like to get all my housekeeping done ahead of time. And I want y'all thinking about these things ahead of time. Because if we're talking about, you keep going back to causation, that's not what I'm talking about. You go to damages, that's not what I'm talking about. But if the statute says injuries, and those injuries are that he was shot, his spleen was missing, his spine was impacted. All of those things are injuries. How do you plan to limit that?
Well, I think you would limit it at he was shot. He was shot 5 times. I mean, those are all part of it. But you would not get necessarily into the medical side of this because again, phase one is we're there to talk about fault for the injuries.
I get that, but they said injuries, Mr. Wellesley. You don't get to tell me he wasn't injured, so he was shot. Okay, but the shooting caused injuries. The shot is the mechanism of injury. It is not the injury. Getting shot by a bullet is pretty much the mechanism of injury, but the shot causing an injury to the spleen, an injury to the spine, an injury to your lungs, that's the injury.
Yes, Your Honor, and the way you're phrasing it there is you're limiting it to the injuries. What the statute says is fault for injuries.
I got that, but when they say fault for injuries, you can't determine fault if you don't let them see what the injuries are.
No, you definitely can, Your Honor. That's what the whole statute is designed to do. Is designed to address fault for the injuries. It's not designed to talk about the injuries. And so the way the court is phrasing it is, yeah, you're going to talk about injuries in phase one, but that's limiting the way if the statute just said in phase one, you can talk about fault for the injuries and causation for the injuries, then you would talk about those types of things. But that's not what the statute says. The statute, as it's worded, is fault for the injuries. That means fault related to the injuries, not the injuries themselves. There's a clear distinction.
But how do I know I have injuries that need to have fault apportioned if you don't let me get into the injuries?
Well, frankly, Judge, you don't. I mean, that's not that's not what the jury is supposed to make the determination regarding fault, not injuries in phase one.
Then why are we here? Because if there was no fault, there's no damages. If there's no injury, there's no damage. You can't even assess psychological damages unless there's physical damages. And so why are we even at a trial? Why am I even before a jury if what I'm saying is, well, okay, we want to know who the bad actor was. Okay, bad actor for what? For his injuries. Well, what injuries? What are you talking about?
Exactly, Your Honor. And the jury will be instructed that injuries and damages will be addressed in phase two. And in phase one, we're here to talk about fault for the injuries. And that's how the determination is supposed to be made. You're supposed to make a distinction and a determination regarding fault for the injuries. And then phase two is the injuries. There would be no need to address the spleen issue that you referenced a moment ago. It would just strictly be about, ladies and gentlemen, there was an
Have you done
incident.
one of these, Mr. Wesley?
No, Your Honor, I don't think many people have done one of these yet, considering the statute's only less than a year old, I think.
Okay, but there have been some, because I'm talking to, like I said, state court is pretty collegial, and we've been talking about this since it passed. So there are judges who've had these cases, and when I tell you, this a fight from beginning to end, and it's not a pretty fight because.
And I'll say I've had this Mr. Woodard's motion almost identical verbatim in 4 cases, I think. So this is not. I know this is making its rounds amongst the plaintiff's bar, but regardless.
No, I'm not talking about the motions practice. I'm talking about boots on the ground when you get into court. What your idea of what the legislature says is and what can come in, but versus what the plaintiff says. And it gets down to the point where just what we're talking about. Okay, so what can he say in opening? The first opening. Can he repeat in the first opening? Can he repeat in the second opening, if we get that far, the stuff that he said in the first opening? Can he, if he doesn't ask for a specific amount in the first opening, can he then ask, like, is he tied to that amount in the second opening, or is he supposed to ask for that? Like, there are all of these ticky-tacky issues. Y'all are excited because you think it's going to limit the jury's desire to give a lot of money. But the issue is y'all are going to be hamstrung about what y'all can say too. So you're going to want to say, well, this is what I anticipate happens in the first phase. Okay, we own this property. So-and-so was walking across the property and he got shot 5 times. We didn't shoot him. That's your case. Mr. Woodard is saying, well, the man.
We're getting a little ahead of the cart on some of the arguments and liability issues that we presented here. But there's a lot more to this one than just that. But again, like I said, we probably.
But Mr. Wesley, you just said we don't get to hear about any of the injuries. We just get to hear that he got shot. Boom. Who shot you? Like is a rap song. Who shot you? That's all we hear. And then you say from that point, we didn't shoot him. Somebody else shot him. He got shot. Now determine who's at fault for him getting shot.
Yes, Your Honor.
Do you anticipate from your side anything else coming into this first phase?
Well, yeah, all the stuff I identified earlier, the contributory negligence, the apportionment, the liability type aspects of the case, certainly.
Okay.
Yeah, those aspects of it, but when you talk about the spleen and you're talking all the stuff you referenced earlier, those items would be related to the damages, the second phase.
Okay. Well, let me parse it through, and I'll see if there's a necessity for me to be the maverick, or whether we just go to trial based on this flawed statute. And I'm not scared to say it because I'm not the only one saying it. I might be the loudest one saying it, but the statute is horrible. And it's because
another option may be to kind of reserve ruling on this until we've dealt with some of these other issues as part of the pretrial phase. And so we kind of flush this out. This case is still in discovery. And so this is very, very early to be talking about some of these issues when we haven't had these items all the way fleshed out. And so another way to deal with this would be to reserve ruling on it until we submit the pretrial. And then if the court is so inclined, we can take it up. And maybe by then, one of these other cases will have made their way to the Court of Appeals and we have a decision that would shed some light on some of these issues.
Okay.
And
look
just,
at it.
I'm not aware of any, I'm not aware of any appellate case law applying the statute as of yet.
No, I'm clear. It literally, we're watching this daily. And so if something had been decided or was even in the pipeline, we're going to get an email about it because we got people who watch the legislation and watch the appeals. And so, yeah, I don't know of anything that's close to being decided by the appellate court at this point. So we will talk about this. This is giving me a lot to chew on. And I shall chew and make a decision. And if I decide to delay my decision based on discovery being ongoing, then I'll give you an order on that also.
and Your Honor, just because Mr. Wellesley mentioned that, this is a procedural issue.
I got you.
It doesn't matter what the facts of the case ultimately are.
It really does not.
Right. And so it's ripe for determination. They filed the demand. I objected to it on the due process grounds. And, I think we could all agree that even if Mr. Wellesley says this is not a bad law, but there are multiple interpretations of this that are not defined by the statute. It's inconclusive and ambiguous as to how the process is supposed to work. And because of the ambiguity and the differences between the old law and the new law, that means it can't apply because it doesn't give us any guidance. It just creates more of an issue than it solves. So
it is
for those
vague
reasons,
and ambiguous.
And it's for that reason it's unconstitutional. And so I believe that the court was within its discretion to decline to enforce that rule or this new law because of those reasons. So thank you.
Your Honor, like I said, there's no ambiguity here. Because if the court meant causation, it would say causation, and it says fault for. I don't want to belabor the point.
Mr. Wesley, you can toe the party line all you want to, sir, but you're not going to convince me that there's no problem with this. I mean, come on. At some point, like when this becomes the topic of all of the judges, we have a email strain that goes back and forth about different issues. And when this becomes the major topic where people are going back and forth and they're talking about what they've had to do and the hoops they've had to jump through to get through a full trial, or what happened in this phase and what they're trying to figure out for the next phase. So yeah, that's not easy. It's not as simple as you're making it. So our case may be factually simple under the rubric of this statute, but the statute itself is not simple and it's not clear. And I'm not going to back down from that. So I'll deal with it if I have to, but yeah, I'm not going to go in here and say, this is the legislature's finest work. No. All right, so I'll make a decision. Thank you all.
I'm sorry, Your Honor, I didn't hear what you said there.
Judge, you're pointed away from your microphone. We can't.
I'm sorry. Yeah,
okay.
I'm just saying. Yeah. So I'll make a decision and I'll get an order out to you all.
Thank you, Judge.
All right.
May we be excused?
Yes.
Hey.
All right. So all right, so the next case, thank you all for your patience. I'm trying to give everybody the opportunity to make their arguments. And the next case that I have is First Portfolio Ventures versus April Rose.
Yes, Judge Matthew Tilden for First Portfolio Ventures.
April Rose is present.
Okay.
Hey, Your Honor, could I briefly say something, please?
Okay, Mr. Deere.
Sorry to butt in. I I have another matter. I've got a deposition set for 1 p.m. It's my fault for not anticipating the timing of both of these two events. Is there any way we could
Is
this matter we're discussing isn't very long. Is there any way we could uh have a hearing on it at some point after my deposition that might take an hour tops, or reset this hearing on a motion for attorney's fees? I apologize.
so is the other party here?
Yes, Your Honor, she is.
Yes.
Ms. Baines? No, I'm sorry, Ms. Kaminsky.
Yeah.
Ms.
Yes.
Kaminsky, you want to give your colleague a little grace, or?
Absolutely. If he needs it, no worries. We can reset this, and hopefully Jason and I can maybe get this case resolved before we have to
I'd
come
love
back.
to do that. I'd love to do that.
I'm working as fast as I can, but some of these issues are a little
Yeah,
waiting.
no, that's
No,
totally
totally
fine, Judge.
understood. It's definitely
All
my
right.
fault. Lauren,
So
I
we'll
will.
reset you all, and we'll get you a new Rule 9 file. If y'all come up with anything in the interim, just go ahead and get us a consent order or whatever kind of order
Okay.
we need.
Okay. Thank you, Your Honor.
Thank you.
Ms.
Thank you.
Kaminsky.
For your patience. Thank you, Ms. Kaminsky, for being collegial.
For sure.
All right.
Thanks.
So Ms. Rose is present. Ms. Rose, I'm sorry. I saw your chats, but I couldn't really respond until I could get both sides on. So Mr. Tilden, she just kept saying, I'm here, I'm present. So I get that. So this complaint was filed. Ms. Rose was served notoriously. This is a debt with respect to credit cards. Ms. Rose has denied owing the debt. And Mr. Tilden, go ahead and present on behalf of First Portfolio.
Yes, Judge. So the motion for summary judgment was filed as a result of defendant failing to deny any of plaintiff's requests for admission of facts. I don't believe we received a response from defendant. So our theory of recovery is that all of the matters that were sent to defendant are essentially admitted by law. And just to keep things brief, Judge, those material facts to which there is no genuine issue includes the fact that $1,147.22 was the amount that the balance when this credit card debt was charged off. That's what we're seeking in the complaint. And we are also seeking court costs of $269. A business records affidavit was filed in addition to all the 902 documents. And we do have a proposed summary judgment order for your consideration that was filed as well.
Okay. So Ms. Rose, you filed a response saying that you don't owe the debt, but what Mr. Tilden is basing the request for a judgment on and for is because they sent what we call requests for admissions. So there's pretty much statements that they will send to you. You're supposed to read the statement, and then you're supposed to respond to the statement, either denying or admitting. And if you don't deny or admit these statements, they are deemed true based on the statute. So did you receive the request for admissions?
I received something asking me to show proof that my identity was stolen and credit cards were attained in my name. And I have been displaced like 10 times since all of this has began. And I didn't have what they were asking me. I didn't have police reports because I don't have them. So I didn't know what else to do. And I wasn't working. So I couldn't get a lawyer to tell them, I can't give you what you want. I've already came to court. I told them of the identity theft. I don't know how to show proof of identity theft because my
Did
identity
you
was
go
stolen.
back to the police and ask for additional copies of what you had received initially?
I had no idea that was an option.
Why not? You got them the first time.
It was, I can't even tell you the years that this happened. All I know is I've been answering and responding to people telling me I have a debt, and I'm like, I didn't do that. I still got one with Navy Federal that I'm fighting. It's a lot of people with my name. And the more I keep saying, I didn't do this, I showed proof. I went through the process of disputing it off my credit. It's no longer on my credit because they deemed, once the first creditor deemed me not responsible, and I showed proof years ago, like 6 years ago, everything else was wiped off.
I get that.
Just kept moving. I don't have it. It was over 6 years ago.
I get that, but did you respond in any way to the request for admissions that Mr. Tilden sent on behalf of his client? Did you? Okay, I get that you read them and said, I don't have this stuff, but did you respond and say, I don't have this, but this is what happened?
No, okay. I didn't know what to say once I received it. Then I thought since it was dismissed, it was over, and it was one less thing I got to keep proving to someone until I got a summons. I got to go to court. And I said, oh, shoot.
Okay, so this is the exact same thing that Mr. Hudson in a previous case was saying. For some reason, in a civil case, if folk think that it gets dismissed, and I don't know because I never sent any order saying that the case was dismissed. You can't depend on what happens with respect to your credit bureaus, with respect to your bank, with respect to even the charge off. Those are not dismissals with respect to the law. Excuse me. A lot of times, what will happen is you are responding to this on two tracks. One is we're calling you, there's a debt, we're sending you letters, there's a debt. To respond in this way, respond to us. But also you're being served with service of process for the summons and complaint for a lawsuit. You have a certain amount of time to respond in a lawsuit. If somebody sends you something and the directions say you must respond within a certain amount of time, which for request for admissions, I believe that is there, then you got to respond. And you can't just ignore it because you don't have the documents that go with it. You got to respond. And when you don't respond, even if you're talking to them on the phone saying, the legal stuff takes precedence, because I've had people time and time again have a default judgment against them and have to pay the money because they thought, because I was talking to them on the other side and I'm talking on the phone with their representatives, that I don't have to focus on the legal. The law takes precedence. And so if they send you something and they're asking for a response and it says you got to respond under oath, you got to respond in a certain amount of days. I get I kind of feel you when you're saying that I was, displaced. I didn't have access to things. I've been fighting this tooth and nail from this thing and this thing and this thing, and it gets chaotic. I get you. But if you drop the ball legally on any of these things, then the law's not very forgiving when it comes to I have a hardship or I'm suffering some issues right now and it's hard for me to keep up with this. And Ms. Rose, as much as I would like to be able to take all of those things into account, because I have to be impartial, I get that you have a hardship, but there is nothing legally that bars me from granting Mr. Tilden's client the motion for summary judgment, because the directions on your request for admission are you got to answer these, you got to send them back, and you got to respond to each of the questions. And you have admitted on the record that you didn't do that.
Right, because once it was dismissed when I went to court the last time, I thought it was an error. And I'm like,
But Mr.
Why is
Tilden,
this keep
I don't
coming
have that
up?
this case was previously dismissed. Is this a refile?
Yes,
I'm not
it
certain,
was,
Judge. This
it
case
was
certainly wasn't
dismissed.
dismissed.
Yes, sir. Hold on, I'll get the actual date. Let me go back to my desk. I came to court, I talked to the lawyer of portfolio, and he asked me questions, and I told him at that time, no, I haven't. This is not me. I have not been there. I have not lived there. On the 23rd, no,
Of,
April 23rd of 24. This was
okay.
dismissed.
Okay, then a complaint was filed on May 16th of 2024, and you were served notoriously at your most notorious place of abode.
Notoriously
March,
means what is?
meaning that they handed it to an adult person at your home or where they believed you resided on March 14th of 2025.
I didn't receive anything on March of
Miss,
25.
but you said you received the.
I got a letter in the mail
Okay.
saying
So,
that they wanted me to show proof of identity theft. And I said, how? How do I
Mr.
show
Tilden, do you have
proof?
the return of service for?
I think I do, Judge, but defendant filed an answer, and it was timely as well.
That's what I have. March 17th of 2025.
March 17th of 2025. And this was after the dismissal of in
Pull
April.
up the image of the answer and send it to me, please.
Yes, ma'am.
Yeah, so Miss Rose, it is possible that the case was filed initially, and when you said, hey, I'm having an issue because I have identity theft, that the case was dismissed. But there's also the possibility that the case was refiled, because it says here that it was served and then there was an answer, a pro se answer, meaning that you answered without an attorney to assist you, that denied owing the debt. Now, if you say you weren't served, but then you answered, that means you're putting yourself into the case. And I get that you're fighting a lot of these, but an answer means you're willing to participate in the lawsuit.
I'm not willing to participate. I want it to go away, but I once it was dismissed, I just put it under the cover. But
Judge, you cut out, but I'm assuming you asked me if I was sending it. I'm working on it. My system runs slower with Zoom open, but I got it in 1 sec.
if I responded and I said I didn't owe the debt, okay.
That's just, I get that, but that's just the beginning of the lawsuit. They file, you respond, and then you guys exchange information to get to the issues or get to trial. Just saying I don't owe the debt because I had identity theft doesn't end the case.
Okay. Okay. Maybe I didn't understand that completely, but I'm here at work now trying to get this resolved. They're chasing me down $4,000. It's off my credit. It's over. It's gone. And I have read that there's a statute of limitation. I didn't sign anything saying that I own this. I didn't take a loan out with them. And if this was over 6 years ago, why are they still bothering me? It's like it won't go away. And I got people, and I kept telling everyone, I didn't do this. And I've shown proof, but I don't have that proof anymore. I've been out of the state and back here, there, and everywhere. I don't have it anymore. I didn't own it. I didn't sign it. It wasn't me. The last lawyer threw it out. Why keep coming back if it's over? I showed proof back then, but I don't have that anymore. And I'm just trying to move forward.
I
Yes,
got you.
ma'am.
I'm looking at your
Okay.
answer. You did answer on March 17th, 2025, and you did in fact say that you were a victim of identity theft, not admitting the debt. I get that. But
Yes, ma'am.
lawsuit is not, it's a marathon, not a sprint. And just
Okay.
because you respond that, and unfortunately, when people can't afford an attorney or don't seek help, and there are agencies that will be income sensitive or help, but a lot of people don't know about them, unfortunately.
No.
But if you're trying to travel this road by yourself, it is fraught with pitfalls, because if you don't know what lawyers know, that is a problem. So you did file an answer. Once you filed the answer, then that begins the period is called discovery. In discovery, both parties can exchange information, and this would have been the time for you to send them your information saying, hey, this is what happened to me. I had an identity theft. But also when they send you, which is the most common thing they do with pro se litigants, send a request for admissions. And if you don't respond to it timely and under oath, then they will file a motion for summary judgment, which is what we're doing now, saying that you have not responded to the motions, the request for admission, and they are now deemed by operation of law to be true. And
Even though I did not say I own that debt and it wasn't me. So because I didn't give them documents that I don't have or know
that,
who
not
to
that you
talk
didn't
to.
give them documents that you don't have, that you didn't respond at all. If you had responded and said, I don't have the documents right now, but this is not true, that's a response. But you didn't respond at all. You
So
said
now I have to take a debt that wasn't me. I can't prove that it wasn't me, and I gotta eat it.
Yes, ma'am.
But I'm not admitting to it.
I get that, but your opportunity to do that was waived when you didn't challenge the request for admission. I know it doesn't sound fair. I'm just going to.
It's not. It's not.
It is not fair. And I'm going to tell you, fair went out the window my first day of law school. There's the law and then there's fair, and they are not the same thing a lot of times. You got me? It is a process. And for people who are pro se, it breaks my heart, but I cannot change what the law says because you are having a hardship. And as much as I would want to be able to tell you where you go or what you do or how to do this, I cannot do that because I cannot litigate or advocate on your behalf.
But it's not a hardship that I'm admitting to, although I was in one. I'm telling, and it's on the record that it wasn't me. It was identity theft. I just don't have a way of proving it. And because I couldn't give you proof that I didn't do it, I have to take a judgment against me for something that somebody else don't have a life to get up and just screw people over. I got to take a judgment.
Ms. Rose.
So I'm fucked up. I'm sorry. Oh my God. I'm sorry. I'm so sorry. I didn't mean that. But that's how I feel in my heart. That's how I feel on the inside. They chasing me for $1,000 that someone else ran up that I said wasn't mine. It was dismissed because I showed them when I went to court that that wasn't me. I didn't live at those addresses. And now you're still they coming after me even after I said to the lawyer that it was dismissed.
Yes, ma'am.
All right. I'm not, I can't pay what I don't have. I'm not, this ain't fair. This isn't fair at all.
The only thing I can tell you, Ms. Rose, is all of my decisions are appealable. I mean, whatever decision I make, there's an appellate court that might make a different decision, but I'm going to send you the order. If you wish to contact Mr. Tilden's client and see if y'all can work something out, even to the extent of you proving to them or sending them information about the theft. And I know you say you don't still have it because you've moved a lot, but you can contact the agencies that you originally contacted and ask and see if they have a copy of the information, because they don't, there are law enforcement agencies have retention times where they have to retain records for certain things. And so it is possible that those records still exist. That's all I can tell you. It breaks my heart on these calendars to have to do this, but I just have to be clear that I don't get to favor one side or the other. I only get to follow the law. All right, Mr. Tilden, was there anything else?
Judge, I'd just encourage Ms. Rose to reach out to Reagan and Reagan. I've sent her in a direct message through Zoom the telephone number that she can use to do that. I would like to just say, even though we don't, we're not getting into the facts of this case, I believe there was a review on this account, and because there were multiple payments made on this account, the conclusion was made that there was no identity theft, and that's why the case perhaps was refiled and why we decided to proceed with it. So again, I just
was the payments coming from me? When were these payments? So again, when was this take?
I don't want to get into all that.
Ms. Rose,
the court's time.
If you would have this conversation with Mr. Tilden or the client offline, that would be helpful. If something happens and y'all need to come back on the calendar because there's been some new change that would cause the court to reconsider, that's one thing. But at this time, the court is not inclined to change its mind or its decision. So you all are free to go at this time, but please continue to communicate because there may be some assistance in that. Okay.
Thank you, Judge. May I be excused?
You may.
Thank you, Your Honor.
All right. So do I have anything else on the calendar that I have not addressed before I get to the 1 o'clock calendar, Ms. Powell?
Double checking, Judge. I think that covers everything, but let me just go through.
Tracy Holmes.
Yes, Tracy Holmes, the garnishment case.
Okay, which one is this? I'm sorry.
This is position 8.
Okay. I'm sorry, Ms. Holmes. Thank you.
I'm sorry, Your Honor. My name is Shelton Foreman. I'm sorry to interrupt you, but I have not been seen. I was here at 11 o'clock.
Which case is your case?
I am here with the Huntington and Debt Holding assigning of capital on tap and Shelton Foreman.
Mr. Shelton was scheduled to appear at 10 a.m.
I don't know. It seems like it. I'm sorry. I guess it said 1 o'clock. I apologize. And I've been here since 11. I didn't see that. So that was an oversight. I really apologize.
Okay.
Oh my gosh. I was
Yeah.
wondering why I didn't get seen.
Yeah, I try to make sure I get to everybody, but if there's if we need to, you just.
The default was issued, Judge.
Yeah, I'm gonna send you out a copy of whatever order we made. Review that, and if you need to ask that something different be done, then you can ask for the court's order to be reconsidered. That's all I can tell you.
Oh my gosh. Thank you so much.
All the people who were present at that time. So
Yeah.
Ms. Powell, Ms. Curtis, I'm looking for your 11 o'clock.
I'll resend it to you.
I just had it a minute ago. No, don't resend it. I'm trying to figure, I guess I've asked you to send so many things that were imaged. So just trying to find the actual one where you sent this.
I can forward it really quick.
Thank you, please.
Yes, ma'am.
Ladies and gentlemen who are here for 1 o'clock, these are pretrial conferences, so we'll speed through those once I get through with this last case. But please be mindful that what I'm going to want to know is the likelihood of settlement. Have y'all talked? Any issues outstanding? Any motions that I need to review or decide prior to being placed on a trial calendar? And then I'm assuming 12-person jury, but if it's a 6-person, let me know. And if you have technical issues, if y'all are tech heavy, please be mindful that I will allow you time if you contact if you contact my office, I will allow you time to come in to be conversant with the tech in my courtroom. But we have to set that up through my office and through the technical advisor in court administration, Mr. Cobble. So those are all things that you can consider while I take care of this. So. All right. All right, so this is Calvary SPV1 LLC versus Tracy Laura Holmes versus Sandu Ministries Incorporated. Who's here on behalf of Calvary? Who's here on behalf of Sandu Ministries?
I am, and there's I think one or two of board members on here as well.
All right, so Ms. Holmes, you're the garnishee, right?
I'm also one of the officers.
I don't know that you can do both.
They're on here.
I'm sorry?
I believe the board members is on here as well.
Okay, I've asked. Nobody spoke up. Is someone here on behalf of Sandu Ministries?
Yes, I apologize. I was getting my mic together. I'm here.
Okay.
I'm
can you turn your camera on and tell me who you are?
Yes.
Uh-oh.
I'm Anthony Johnson.
Okay, you're not going to be able to drive while we're on the hearing?
I'm pulling over.
Okay, because that would be distracted driving, and I would hate for you to get a ticket. Okay, and what's your name, ma'am?
Anthony Johnson.
You're going to have to spell that for me.
V as in Valentine, ANITININE. Last name Johnson, JOHNSON.
All right. So, Ms. Johnson, what position do you hold with Sandu Ministries?
I'm the sorry, Judge. Can you hear me?
I hear you.
I'm the chair.
Okay. All right. All right, so this is a continuing garnishment was initiated. There was the defendant's claim that defendant claims they're not an employee of the garnishee, but instead a volunteer board member and pastor receiving no funds for the service. The only income is exempt from garnishment. So did Sandu Ministries respond in this way?
Yes, Sandu Ministries responded and I responded.
Okay, so Ms. John, so who received the information requesting that wages be garnished?
I received them as well as the church received them.
Okay, and for the church, who received them?
It came to the church address, so the church, everybody's seen it. Or I'm not quite sure what you're asking.
Well, Ms. Holmes, it is not common for me to talk to the garnishee and as a garnished person who's being garnished as a representative of the garnishee. So there's some veracity issues there. Not that I would say that you are lying, but if you say, I don't work for them, but it's their responsibility to respond to say, hey, she's a volunteer. We don't take out any salary. There's nothing to collect in response to this garnishment. It would appear to be a conflict for you to respond as both the garnishee and the person who owes the debt. So what I'm saying is there somebody who responded on behalf of Sandu Ministries who is not you?
The board sent, well, what they did was they sent an entire packet. And in that packet, and I guess then Janine can speak too. But in that packet, they shared that I'm a volunteer.
Okay. Did they get any response from the plaintiff in this case?
I'm not quite sure what you're asking. They sent it to the church.
No. So
No, after we made the packet, we did not receive anything.
okay. And nothing was filed at that point. Ms. Powell, was there any response from the plaintiff to the fact that they're saying that that they made their response?
No, ma'am.
All right. So, okay. So it would seem that this garnishee has responded and there's nothing to garnish, but I need to look at it and see what order I would need to, because there's nobody challenging. If the plaintiffs didn't challenge that, saying that, yeah, there's money and we know that you all haven't collected what you should have collected, that's one thing. But if they haven't made any response to the garnishee's filing that the garnishee doesn't have any money because they don't take out it, they don't pay her anything, then that's another thing. So I would make a decision based on that. The plaintiff was given the opportunity to appear today and did not. So I would take the information presented by the filings and also here today with respect to this issue. So it is my understanding that Ms. Holmes, what you're stating is that there's nothing I don't work for them. There's nothing to be taken out of any paycheck because I don't receive a paycheck.
Correct.
All right. All right. So I will get an order out. The order will go to you, Ms. Holmes, as the defendant, to Ms. Johnson, Ms. Powell, if you could make sure that Ms. Johnson, as chair of the board for Sandu Ministries, is the person who receives the order on behalf of the ministry from the court. And then we will make sure that we get this order out to you.
Thank you.
Thank you.
All right. But you see my point, Ms. Holmes. I can't.
Well, I mean, the thing is,
on behalf. Okay.
They know. I mean, the thing is, they already know. They know I don't get a salary. I think this is just we want her on video. We want to embarrass her, but I don't get a salary.
I get you, ma'am. Well, hang in there, and I will get you out in order. Okay.
Thank you.
All right. And thank you for your patience. I know it's been a long time. Does somebody have a question?
Yes, ma'am. Just for clarity, do you want us to send the order to Sandu Ministries as it's currently on file, or would you like the chair to send me her information so that she can also?
No, I want you to attach her name as chair.
Okay.
To whatever they have on file. So I want to make sure I have a person of contact who appeared on their behalf.
Would you please?
And I have. I'm over the church email as well. So sanduministries@gmail.com comes straight to me.
Okay, cool.
Would you state her name again, Judge, for the record, please?
I wrote it down.
Okay, thank you.
Yeah. All right, so we are good to go.
Thank you, Judge. Can I be dismissed?
Yes, ma'am.
Thank you.
And thank y'all for your patience. I appreciate it.
Bye-bye.
Thank you. Have a great day.
Take care. All right, for those of you who are here for the 1 p.m. calendar, let me get to that. There we go. All right, first case on the calendar is Hooks, Shernika Hooks versus Balloons and Parties LLC. On behalf of Mr. Hooks is Mr. Rodney Davis.
Yes, Your Honor.
I'm sorry, Ms. Hooks is Mr. Rodney Davis. And on behalf of Balloons and Parties is Mr. Rouse.
Good morning or good afternoon.
Good morning. All right, so are we ready for trial?
The plaintiff's ready, Your Honor. On behalf of the defendant, no, we are not ready, Your Honor. I had the opportunity to appear before the court about a year ago. and I expressed concerns about the preparation needed for this case. As the court is aware, this is a premises liability case, and the sole defendant in this case is a service provider who was not the landowner or occupier, was not in possession of the item at the time of the incident. In fact, the tent in question was erected the day before this incident occurred, and on July 24th, it was erected July 24th of 2020.
Mr. Rouse,
yes,
I'm gonna need you to cut to the chase because this is a conference, like a pretrial conference. It's not tell me everything about the case.
Yes,
tell
sir.
me what you need and what's outstanding that you're not ready for trial.
Okay, there were admissions in this case. This is a very straightforward case. I think it's a case that should be disposed of on a motion because correct parties have not been made a part of this case. We submitted requests for admissions, and in conjunction with those admissions, we asked if you deny a certain statement, then supply the supporting evidence. There were plenty of denials, but there wasn't any supporting information included. And in terms of just preparing the case for trial if needed, so that we're not wasting the court's time, we sent out a notice for deposition for Ms. Hooks. And we've pursued that deposition. We've contacted the plaintiff's office. I've emailed the plaintiff's attorney multiple times, and there have been just no response at all about the case, about the theories of the case, about whether they're going to appear for the deposition, about documents supporting the admissions, nothing. And in fact, the only email that I've gotten in the past year is the email related to the PTO. And there were challenges even getting the PTO consolidated. So what we need to be ready for this case is to at least have the supplement of the information for the admissions.
So how did I rule on the motion to compel that you filed?
He didn't file it, Your Honor. Plaintiff filed a motion to compel.
Mr. Davis, I work alone. If I need you, I'll tell you.
Okay, I'm sorry.
I'm clear.
Well, Judge, I appeared at a peremptory calendar, and I appeared in person, and I expressed the concerns that I had, and I asked for.
I get that, Mr. Rouse, but you expressing your concerns verbally to me without filing a motion to compel or asking for a telephone or Zoom conference to get the discovery issues worked out is like somebody saying thoughts and prayers. Okay, and that gets us no closer to trial. So what I'm saying is you have a mechanism by which you can force all of these issues forward. You have not used such mechanism, and you come before me a year later saying, a year ago, Your Honor, I was pointing out all the problems we had, but you didn't tell me that, hey, we've worked through this. I've done the Rule 64. I've tried to talk. They're not giving me what I need. Let's go through a discovery reconciliation process so we can get on the right track. And so you telling me now that I came and I told you what the issue was a year ago, and then you coming to me a year later and saying it's the same issue doesn't tell me anything. What it tells me is you have not availed yourself of what is statutorily required or provided to you in order to move the case forward. So tell me why I shouldn't put this on a trial calendar and say work it out once you get before a jury.
Well, I believe that this case will take at least 2 days, and a lot of that time can be resolved if a 30-minute deposition occurs, which would save the county resources and the jurors that appear resources. And so that is the reason.
And what's been the holdup in the year where you first expressed concern?
My misunderstanding was I thought that I had leave when I made that representation, and the court responded, I thought, favorably to that. I thought that was sufficient. Obviously, I was in error.
Mr. Rouse, okay, what you're not going to do is throw it back on me, because if you express something And I said, okay, y'all need to work this out. And y'all, it doesn't get worked out, then you elevate it to the next level. I don't like sloppy lawyering. And so what I'm saying to you is, if there's a mechanism by which you can push this case forward and you didn't avail yourself of it, then you come back to me and say, well, Judge, I told you what the problem was. Well, you know how many cases I have? Let's talk about just the cases on this pretrial calendar. And so if I were to go and have to call back and say, hey, did we get that worked out on every one of the cases? I have a products liability case that has probably about 8 lawyers. I have a med mal, probably another 8 or 9 lawyers. And so if I had to handhold each of those lawyers on each of those cases, then I'd be really, really busy. So what I'm saying to you is, your failure to move the case forward does not make an emergency for me. At this point, I'm ready to put the case on a trial calendar and do what you do. But not sure why I'm hearing a year later that I'm still having the same issues I had a year before.
Yes, Judge.
Okay, so 12-person jury, correct?
12-person jury, Your Honor.
Okay. And anything else we need to know? Y'all need any motions outstanding? Any tech assistance? Mr. Davis, anything?
No, ma'am, I don't have any motions outstanding.
All right. So we'll be looking to see you at the next available trial calendar. If the pretrial order, I believe, has been filed. Is that correct?
It has, Your Honor.
All right, then we're good to go.
I finally spoke with Mr. Davis this afternoon and consolidated the pretrial order.
Okay. Well, sounds good. Sounds like y'all are ahead of the game. All right. So it's premises liability. Been there, done that. So I'm gonna be ready, and I will see y'all when y'all get there. Okay.
Just confirming, what's showing in the system is proposed order for portion of pretrial order, and just confirming that like the full pretrial order has been filed.
The pretrial order that was filed was PTO. It had the same style as the one previously provided to the court on behalf of the defendant, but it's just PTO by defendant draft consolidated 1, includes everything. So that was the version that was filed.
Thank
you. Okay. Anything else, Ms. Powell?
No,
ma'am. All right. Unless there's anything else, y'all are free to go.
Thank you, Your Honor.
You're welcome. All right. Kenneth Cade versus Heritage Cadillac.
Good afternoon, Judge.
Good afternoon. Okay, so here we have an issue. So we have Heritage Cadillac, which is an incorporated business, but we have a pro se litigant on behalf of Heritage Cadillac. We have what we call an Eccles problem, because in state court, an incorporated business cannot be represented by an individual. It must have an attorney to represent the business. So, okay, what's going on?
Well, I'm just trying to figure this out. I think I took over the store maybe soon after this issue arose. And long story short, I see we filed a response to it some time ago. I don't have the exact date. And my personnel were under the impression that this was thrown out once before. And then all of a sudden we get this across our desk. So I'm just trying to figure out what happened. I can get a lawyer involved. It's not a problem.
Well, that's the issue. We're already at a pretrial conference and you haven't gotten a lawyer. This is the issue that I have with business people. Y'all know business, but you don't know law. But anything legal comes up and y'all think y'all can handle the legal stuff as well as the business stuff. And this is the legal stuff is what'll kill you. That's what will get your business cut out. What I don't understand is you do what you do, but nobody would ever wants to say, let me bring in a lawyer to handle the stuff that I don't do. I don't do cars. I don't do Cadillacs, but I do law. And what I don't understand is somebody who does Cadillacs trying to do law. If you took over the business, and this is just common sense. If I take over a business, the first thing I'm going to do is do a review. I'm not only going to do a financial audit, I'm going to do an audit to see if there are any legal issues outstanding. And then I'm going to consult with a lawyer to make sure that I'm good on all my contracts, all my business documents, on anything that I need to collect on. So I need to know, did you get an attorney to come on behalf of Heritage?
I did not, ma'am.
Okay. Start thinking business wise. Everybody who thinks there's a business person and you can do your business, business also includes law. And if you don't know that part, it will crush you. I'm just telling you. Mr. Cade, Mr. Hillman Toombs is on behalf of Cade. Is that case like it? Did he get a conflict? Where's Mr. Toombs? Ms. Powell?
I'm sorry, Judge, what'd you say?
Where's Mr. Toombs?
He did receive notice.
He's what?
He did receive service. So, and I did not hear from him that he wouldn't be here. Did you, Miss Val?
No, I have not heard from him. Notice it go to him.
All right. So, Miss Val, we're going to take this off of this calendar. Mr. Toombs has not appeared without excuse. I'm not going to ding his client for that until I figure out why Mr. Toombs is not here. What I'm going to do is we're going to take this off the current trial calendar. Mr. I don't even have your name, sir, but you're going to get a lawyer on behalf of your business. And your lawyer is going to talk to Mr. Toombs, and y'all going to see if y'all can figure this out before we pop up on another trial calendar, okay?
Not a problem. Consider done.
All right. And please spread the word amongst your business friends that they don't get to handle everything. Just because you know selling cars doesn't mean you know law. Make that your cry that you sing out to everybody. Because I'm tired of businesses showing up, and this is a crucial aspect of protecting your actual business, and everybody thinks they can handle it. We clear?
Very.
All right. Thank you.
Thank you.
Is Arias Bass versus Michael Clark, and Central Transport, Cherokee Insurance versus Anthony Obrandt.
Good afternoon, Your Honor. Jason Wyrick and Emmeline Harder for the defense.
Good afternoon, Your Honor. Jeff Beard for the plaintiffs.
All right.
Your Honor, the parties have submitted a consolidated pretrial order. There are several motions pending before the court. The defense has filed a motion for partial summary judgment. I have met and conferred with Mr. Beard regarding the issues that are the subject of that motion. And the plaintiff, as I understand it, is willing to concede the punitive damages claim and the attorney fee claim such that summary adjudication is appropriate for those claims and that those issues don't need to be heard. The remainder of that motion pertains to the direct negligence claims, as I understand it, that will be opposed, and the defense would request a hearing on that aspect of the motion. Additionally, both sides have filed motions in limine. The defense would request a hearing and the opportunity for a written order, if possible, on those motions so that the parties can have a roadmap for trial given these issues. The defense would suggest a short continuance. I believe we're on the February 23rd calendar. This is the first time this matter has appeared on a trial calendar. I think it could be a short reset to have those issues heard, but that would be our suggestion. Regarding settlement, we're not all that far apart in the grand scheme of things on this, Judge. The defense thinks this is a case that should be settled. I suspect Mr. Beard agrees with me on that. It's just a matter of getting our clients to agree on a number. We'd like to keep talking and to see if, we could do that. We have mediated the case twice. And so, we've done 2 mediations and are without a settlement agreement, but, maybe I'm overly optimistic, but I'd like to keep those discussions open. That is essentially where we are, Your Honor.
So this is one of those trifurcated cases under the new. I just had a very long, very interesting motion about the new tort reform law, and so this will be trifurcated under tort reform. Correct.
Well, Your Honor, if I may interject, I do think the concession on the punitive and attorney fee claim will eliminate phase 3.
Just a bifurcation at that point in time. I think that Jason and I are in agreement on that.
Okay.
And to the extent that with it, what Mr. Wyrick has represented. Otherwise, I don't take any contention with those issues. Plaintiff is ready otherwise, as far as that goes.
Okay. So we would have substantial pretrial motions prior to this, because getting these types of cases, this will be, if I can get one to go to trial, this will be my first actual trial on the new on the tort reform cases. So the issue that I have is when we talk about, and I just had a lengthy discussion about this, is when we talk about the phase one and the determining fault for injury. I need what y'all consider fault, and I need what y'all consider injury, because I need to know how far each side is going to be able to go with respect to putting in information about injuries, putting in information about fault, causation, all of those things. Tell me what you think your first phase looks like, and tell me what you think your second phase looks like. So that when we get to the motions and limine portion, and we'll go ahead and get that set. I want to know what you think this trial is going to look like.
Your Honor, candidly, that was going to be one of the questions that I was going to ask the court, but given the court's instruction, I think it would be beneficial for Mr. Baird and I to talk, and we will report back with our position on that. I also had a question about, is the testimony from phase one going to be used in phase two, or do the parties need to essentially start over?
Well, let me just tell you that this has been the hot topic among state court judges regarding some who have already tried cases under the tort reform, and some who have not. But we've gone back and forth on a lot of these issues. I've been monitoring the email traffic, but the issues tend to be what comes in, what gets reused in phase two if we get to that phase, and then what are the limitations of quote unquote, because the difference is injuries versus damages. And so what are the limitations for what you can put in as injury versus damages? And I just had this discussion on a case, which is premises liability with a shooting. And so I said, okay, you are trying to determine fault for injuries. If the person was shot multiple times, does the injury issue end with the police report? Like, do we get anything past that? They were in ICU, their spleen was hurt, or is it just that they were shot and now we got to figure out who's at fault for the shooting? Or does the definition of injuries go beyond just what happens at the point of impact of whatever the case is? So that's something I want y'all to suss out for me.
The concern is we don't really have a lot of guidance at this point in time.
We do not. We have no appellate guidance. The plaintiff's attorney in the case I'm talking about was wanting me to be a maverick and help them make some guidance, but I don't know. There may be some cases already out of the gate with respect to going up to the appeals court. But what I want to know is, because everybody has such a different view of what phase one and phase two look like, what I want to know is when they say we're determining fault for injury, what is the length and breadth of what we can talk about as far as injuries, and what is the length and breadth that we can talk about with respect to causation, and how does that play into fault?
So in light of the court's instruction for the council to meet and confer on that issue, does it make sense to take this case off the February 23rd calendar, to set a hearing for the pending motions, and then the parties can have some opportunity to do exactly what Your Honor just asked us to do, and to be ready to discuss that issue at the hearing?
All right, Mr. Beard. Because Mr. Beard is ready. He was already in court putting his tech up. So I'm just saying, he's ready.
I mean, Your Honor, we are ready. I understand the court's concern, and of course, we want to comply with the court's concerns in order to address these issues specifically. And one of the questions from the plan.
Are y'all not concerned?
Yeah, of course we are, Your Honor.
I mean, I'm just saying. Okay, so this is my thing. I like clean trials. Civil trials with professionals who, the less I have to do in the midst of trial, the better the trial is. I don't get in y'all's way. I want you to be able to put on your case the way that you're accustomed to doing so. As long as it stays within the confines of what is reasonable and legal, I try not to mess with you. And so in order to have a clean trial, we have to do the work pre-trial. And so what I'm saying to you is I need to know what each of you, because we're all new to this, what do you think this looks like? What is the limitation of what you believe the other side can or cannot do? Same thing, because once we have an idea of what your expectations are, then we can sit together and kind of chop the tree down and figure out what it's going to look like.
And I agree that that's appropriate, Your Honor. And I agree that while I have no contention with anything Mr. Wyrick has said as far as how this should be worked out, I have been instructed to announce that we are ready to go. So I
got you.
I guess I've said what I need to say, Judge.
I got you. So we will have to come up with a time for some significant motions practice, motions hearings.
Judge, you cut out at the start of what you said. We couldn't hear you.
Yeah,
I'm sorry. I need my
there,
external mic. Ms. Val, what's Ben saying about my external mic? Tell him I'm going to order my own from Amazon if I don't get it.
It's ordered. We're just waiting for it to be delivered, Judge.
Where's it coming from? I'm just
Hopefully
saying.
this week.
Okay. So tech issues aside, yeah, let me talk to some of the other judges and see how long their motions in limine on these cases have taken. And then we'll determine whether it makes sense to, if we want to take up the Monday prior to calling in the jury and getting it done, and then, or whether we want to take up the prior Friday. So it all depends on those kinds of things.
So as we sit here, for now, Your Honor, is this case going to remain on the 23rd, or are we going to move it from that calendar to set a hearing date on the motions? And I guess as Your Honor ponders that question, may I ask, is this a 1-week calendar?
It is. And that's the other thing with these cases, is trying to figure out how much time to allocate once we determine it's bifurcated versus, like, if I have to move some things, I generally tend to kind of leave the Monday and the Tuesday flexible into the next week. But the problem is that we have absolutely no idea to determine how long each of these phases is going to take.
And that's the trouble, Your Honor. The parties jointly, recommended a 4 to 5 or estimated a 4 to 5 day trial. I do agree eliminating phase 3 is helpful. As I think through this case, I'm a little bit wondering if this case could go longer. And again, like the court, we have very limited experience with multi-phase trials. This is all new, but obviously we're looking at, at least potentially 2 deliberations. Obviously, if this is a phase 1 case, I think it would be completed within the trial week. If not, could it roll over? I think it's possible. Both parties are going to have expert witnesses. Both parties are probably going to have multiple expert witnesses. And so this is a case that could take a little while. So, I don't know what Your Honor's position is on specially set trials.
I never do. I will set a trial first out, but I don't specially set, because if I set you first out, and it's happened to colleagues of mine, they've cleared 2-3 weeks for a particular trial and then get to the trial and things fall apart. So I will set you first out if I believe that the trial needs particular consideration, but I don't specially set. Yeah.
Does Your Honor run multi-week trial calendars? But if no special set, perhaps it makes sense for us to be position number 1 on a 2-week calendar, wherein we have some extra room. I know it sounds like, based on the previous case, we've got at least 1 case ahead of us on this calendar. And, this is not a case that could be tried, in 2 or 3 days.
I would agree with that.
All right, let me, I think the arguments are well taken that maybe this needs a bit more attention.
Part of the reason I'm pressing, Your Honor, a little bit is we've got expert witnesses that we,
I get
that are going to be live and that want to know when they're supposed to be there. And I'm trying to be able to give them an accurate answer when we can.
No, I'm sensitive to that, but I generally say that I will give you first out. That way, that you can pretty much rely on having your witnesses there. As long as y'all don't break down, I'm going to be there. But what has happened in the past is, you especially set a case, it breaks down, or they settle I can't tell you how many cases of mine settle the Friday before, the Thursday before, or the morning of, and then I'm stuck with unscheduled time that I could be using for other cases. And so, like I said, I will put you first out. This may be a case that is posturally something that could go longer. The only issue that I have is that this is going to be essentially from now on, this is going to be all of my cases, because of the fact that all of them could trifurcate, bifurcate, and so at this point, we're probably going to set, instead of doing civil calendars every month as I've done them since I took the bench, I'm probably going to start just doing them maybe quarterly or every other month, and then doing multiple weeks and force as many cases on those weeks as I can.
Can understand and appreciate the court's position on all that, Your Honor.
So give me a minute to get with my case manager and with my staff attorney, and then we're going to kind of work out how many days we think we'll need for this, especially for the motions practice part of it.
May we ask, Your Honor, I'm sorry, go ahead, Your Honor.
Go ahead. I was going to say, you got a partial motion for summary judgment that's hanging out there, and y'all seem to have whittled that down pretty well. But you still have a part that needs to have a hearing.
That's correct.
Yep. Yes, Your Honor. Your Honor, are you able to tell us when the next trial calendar is? In other words, if it's not that far out, that might, I'm sorry, go ahead.
We may already have cases that are set for that calendar. Ms. Val, do you know when the next one is?
Yeah, we have a March 30th calendar, but we do have other cases also.
I'm sorry?
March 30th, but we also have other cases also.
Yeah, we put some cases that probably should have gone on the January or February calendar. We've already started to push them to March 30th. And I don't want to put y'all in a position where, oh yeah, we've had 5 cases come off that calendar, we can put you on. I don't want to do that and not give you the opportunity to be prepared to go forward.
Understood, Your Honor.
Especially, Judge, if anticipation is a 2-week trial, then we will need a little time to get that figured out.
Okay. So
that one may back up to my leave of absence a little bit as well. I think I've got to leave starting April the 6th, depending on when it starts. Yeah, not trying to create troubles, Your Honor, but
no, I would rather know ahead of time. Mr. Beard is looking very, very dejected because he was ready to go.
For the record.
For the record, I got you. But all of these are things that have to be considered. We have these conversations because I'm looking at when my staff attorney was like, yeah, this might be one of them, Judge. But do we want to take a jury into a Saturday?
no one wants that, Your Honor.
Nobody.
Not the defense.
Nobody wants that. And I've had judges get right up to the edge of it on these cases. And so, like, I didn't know the first deliberation would take this long. And now we're into the second phase and we're running up on a Saturday. And so it's a lot. But let me suss it out and see what changes I might need to make in order to give y'all the time that this is going to need. But
understood.
But prior to your trial, because I'm thinking I'm leaning towards moving you off of the 23rd.
Your Honor, we're having a little bit of trouble hearing you.
I'm sorry. I need my
didn't mean to interrupt you.
No, that's okay. Prior to the trial, I really need to get all of these issues kind of sussed out as far as what y'all see phase 1 and phase 2 looking like. and then doing the motions in limine so that we have the law of the case set, so that when y'all come in, there's no, well, Judge, we need to talk about this outside the hearing of the jury, like excessively. I want to be able to just, we know what we can say, what we can't say, and I want to be able to go straight through.
And given those issues, Your Honor, and given that we're, a week and a half out from the start of the trial calendar, does it make sense to take this thing off? And I understand plaintiff is going to object, and he's got a client to answer to. But in light of those issues, we would request that this matter come off the February 23rd calendar and be reset once those issues are addressed.
I'll get you a decision on that by tomorrow.
Understood, Your Honor. Appreciate that. Thank you.
Mm-hmm. All right, but I do applaud the fact that you all have kind of tried to whittle this case down to something that makes sense. You've gone to mediation twice. You've already kind of talked it through your partial summary judgment. You've pulled that down to the point where it's manageable. And so I appreciate that. And I will be mindful of the issues on both sides. Like Mr. Beard's client wants to go ahead and get this taken care of, but I do understand that with the tort reform and neither of you have tried such a case.
No, Your Honor.
So,
no, Your Honor, I'm prepared for a couple of them, and probably I'm going to try a few of them this year, but I have not had the opportunity yet.
I think this year is going to be when the floodgates open. We can't avoid it anymore. And I think that this is going to be the year where we really will have to figure out how it works. And, like how much time we, allocate to what we used to consider a simple car accident case versus something that is more weighty with respect to the number of issues that have to be determined, such as like a med mal or a products liability, both of which I have on my schedule this year. So I'll get you an answer tomorrow.
Thank you, Your Honor.
Thank you, Your Honor. We appreciate it. May we be excused.
You may.
Your Honor, I have one quick question with regards to the Demia Hudson matter, which I'm also on. The defense had asked for a continuance on that, and we were supposed to file the pretrial order. We have filed the pretrial order, and there was our understanding. I have not spoken with defense since then, that we would be excused for the Demia Hudson pretrial this afternoon. I just need to
consolidate it.
Yes, Your Honor.
You're excused.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you. Nice talking to y'all. So next case is Allstate Property and Casualty and subrogate of Thomas Mays.
Good morning, Your Honor. Good afternoon, Your Honor. Keisha Townsend for the plaintiff.
Good afternoon.
And Brad Rutledge here for the defendant.
All right. Tell me what we're looking at. Is this one of my special cases?
I think we're pretty straightforward. We did submit a CPTO this morning. I don't think that there's really any big issues. It's like a $4,000 case, straight up property damage subrogation claim. It would take a day.
Okay, sounds good. Any issues? How many jurors we're gonna need?
6.
And
oh, sorry, Brad. Go ahead.
Sorry. And my only issue is we had some unexpected testimony in a deposition we took earlier this week, and I would like to get the police body cam and/or dash cam footage. So I would just like to request a very short continuance, if at all possible, so we could get that footage.
When did this become an issue?
I believe we took the deposition on Monday.
Okay, and do we anticipate that it's going to take a long time to get it?
I've had difficulties getting it before. I've had cases where we couldn't get the police report. It's taken a month or 2 months. But I
Okay,
think that's
and you're talking about body cam. Was there a citation issued in this case? And I don't want to know who got it or what. I'm just wanting to know, was there a criminal element in this case?
there was a citation issued.
All right, I would check with the solicitor's office and find out if they have it, because that'd be easier to get. from them. And also make the effort because I don't want to take this off the calendar. If I can get it tried, it's a quick and simple case. And if that wasn't anticipated before, not sure. I don't want to know what issues it brought up, but do make the effort to get it done as quickly as possible and take a multi-faceted approach, meaning try the solicitor's office, try the police records room, try all of those things. Maybe the defense attorney has it, because you have a better chance of getting it that way than relying on one source. That's all I say.
Yes, Your Honor.
All right. All right.
Judge, will you remain position number 2?
Yep.
If called, you'll be position number 2.
Yeah, we'll call you when reached. But we try and give you as much knowledge ahead of time. Like as soon as we start seeing cases coming off the calendar, we kind of try and give you some heads up.
Okay, so we're not going to be first out on Monday, as of right now.
As of right now.
Okay.
But don't lay back, because you could be.
Oh yeah.
I'm gonna tell everybody. I say this all the time. People dive off my calendars like there's gold in the water. So come Thursday, Friday, before the trial calendar, I mean, folks start like, oh, I'm dismissed, or we've settled, Your Honor. Okay.
Yeah, I'm hoping that with Brad, we can get some money on this for $4,000. So we'll see. We'll see. But I think it'd be a 6-person jury if we do move forward.
All right, sounds good. Thank you.
All right, thank you. Have a great one.
Thank you, Your Honor.
All right, you too. Pleasure. All right, so the next case is, all right, Mr. Toombs. Where were you? So here's the thing. We moved your case off the calendar, Mr. Toombs, and for this reason. One, you weren't there, and I didn't want to ding your plaintiff. And 2, because the gentleman from Heritage Cadillac is trying to represent Heritage Cadillac, and that's an Eccles issue. He doesn't get to represent them. And y'all need to talk. He needs to get an attorney, and before y'all show back up in front of me.
I was on my way to my office, Your Honor, and I got stuck behind an accident. I'm sorry.
Okay. But that I don't know when y'all will pop up again. Be mindful of that. But what I'm saying is, yeah, this case is not in a posture to be tried because nobody seems to know anything.
Nobody seemed to know anything.
Yeah, you weren't here, and he was the business owner, but not an attorney.
Right. Okay.
All right.
Well, we like for it to be stay on the calendar. We don't want it taken off the calendar, Your Honor.
It's not going to be tried on this calendar.
Yes, I understand. I understand that.
No, I'm saying it will come up on another calendar. It's just not going to be tried on this calendar.
Okay.
Because I'm not going to waste like picking a jury when they can't go forward without an attorney.
Yeah. Okay, so you're going to give him another chance.
I don't know that I've ever given him a chance. This is the first time I'm hearing about this case. Had y'all come up on a motions calendar, I would have told him a long time ago, hey, you need an attorney.
Yeah.
I'm supposed to have to do that. I shouldn't have to. But these business people keep showing up with no attorney. So had it come to my attention earlier, I would have done that. But there was nothing that triggered me having to weigh in.
Okay.
All right. So we'll see where we go with that.
Okay, that's all I have. May I be excused?
Yes, sir. Thank you.
Thank you.
All right. So next case is Antonia Floyd versus Riley Shamir Alquin and Thomas Don Juan.
Good afternoon, Your Honor. Spencer West here for the defendant, Don Thomas.
Good afternoon.
Oh, I'm sorry, Don Juan Thomas. Okay.
Good afternoon, Judge. Jillian Todd here for Mr. Todd on behalf of the plaintiff.
All right. Good afternoon, Ms. Todd. All right. So this is the consolidated pretrial order needs to be filed in this case. This is a vehicle collision. And so I'm just trying to figure out where we are. There are motions outstanding. There's a motion for service by publication that was filed on the 5th of February and a motion for a continuance.
Yes, Your Honor.
Okay, tell me what's going on.
Okay, so this case was originally filed against 3 defendants. The one defendant, Jack's Automotive, was dismissed out of the case, and that left Don Juan Thomas and Shamir Riley. We have attempted many times in different states to locate Mr. Riley, which is why we filed the motion for service by publication as to Mr. Riley. And then obviously Mr. Thomas, but Attorney West, they've filed an answer on Mr. Thomas's behalf. So that's the motion for service by publication is as to Mr. Riley. And yes, Your Honor, that was filed on the 5th. You're right, correct. And then the motion
2023 case. Why have we waited so long to file the motion for service by publication?
It was more of an oversight that that we hadn't been able to locate him. And so that's how it happened, Your Honor. I don't have an excuse other than that we had been making attempts to serve him. We had hired process servers to try to do a skip trace to locate him. We thought we located him in another state. That turned up not fruitful. So we still haven't been able to locate him.
Okay. Mr. West?
Yeah, we have no objection to continuance. Yeah.
All right.
And the motion for continuance, Your Honor, obviously we haven't, we have also, I didn't know, and I have not spoken to Mr. West, so I'm saying this, and I don't even know if this is something that he would be, because we haven't participated in any type of mediation or settlement or anything like that. So I didn't, and again, I don't know if he's agreeable to it or not, but that was another reason to request to see if there was any interest in having the case go to mediation.
Okay, so here's the thing. This is a 2023 case. Unless there's some catastrophic injuries that I'm not aware of, this is something where treatment should probably be either finished or nearing the end. Once y'all have all of that on the table, then mediation seems to be the best bet because y'all can sit down and start talking about where you are with respect to settlement. It doesn't appear that there's any additional discovery absent Mr. Riley's entry into the case. And if he files an answer, then that opens up, more discovery. But let's check in and let's not let this case linger. Let's check in and see where you are with respect to settlement possibilities, what discovery needs to be done. So if Mr. Riley is served by publication, what happens going forward? Because I think that the basis of the case should be like the treatment and all of that should already be set. So we should know what potential damages are likely to be.
That's correct, Your Honor.
Mr. West?
Yeah, I think I continue. Also, I can't remember off the top of my head, but I think this case is also appropriate to bifurcate as far as liability, or if you would allow us, we'd be happy to file a motion for summary judgment on that issue. I think we have a strong case. I know that we haven't filed it yet, but that was also an oversight.
Okay, to file a motion for summary judgment on what issue, Mr. West?
On the negligence issue for liability for causing the accident on behalf of Don Juan Thomas.
So, okay, because you're talking about bifurcation. are you filing a motion for summary judgment because there are no genuine issues? Or are you filing a demand for bifurcation? Because that's two different things.
Well, I think we would do either or. If you allow us to file a motion for summary judgment, we wouldn't then we wouldn't file a motion to bifurcate.
Okay. What I'm asking is, how does one substitute for the other? The motion to bifurcate means that you have a case that is $150,000 or more. A motion for summary judgment doesn't generally deal with the amount of money unless there's a default. So what is the motion for summary judgment going to do? How does that inform me with respect to the issue on bifurcation?
So my understanding, Your Honor, bifurcation is you can have two separate trials, one deciding the liability without injecting the damages component into the case. And our motion for summary judgment would be on the issue of negligence, whether or not Mr. Thomas was in any way responsible for causing this accident.
So that the remainder of the case to be tried would just be damages. Ms. Todd?
Well, Judge, on the bifurcation issue, again, that only has, as Your Honor said, that that is if we're seeking an excess of 150,000, then that would warrant the bifurcation of between liability and damages. So that's his prerogative if he wants to file it, and then we can of course file a response if we're not seeking an excess of 150,000. And that's that part of it. On the motion for summary judgment, I believe any issue regarding liability with negligence, that's a jury question. So that wouldn't be a fact, or that wouldn't be an issue of law for the court to determine. Again, that's Mr. West's prerogative, but obviously in my experience, if you're questioning liability or negligence, that boils down to a jury question. That's not an issue of law. For the court to decide. Again, that's Mr. West's prerogative, but I also
that's why I kept asking.
Issue. I mean, it's they're not connect. Meaning
that's why I kept asking the questions. Like I don't see a nexus between a motion for summary judgment and the demand for bifurcation. If you want to bifurcate the case based on it being $150,000 or more and not one of the exceptions, then fine. If you want to have a motion for summary judgment because you believe there are issues that we could resolve as a matter of law prior to going to trial, that's fine. But I don't see that those issues are connected. I'm not going to tell you how to try your case, but I will address whatever comes before me.
Yes, Your Honor. Well, there's two defendants. There's a 3-car accident. So issues of negligence is a matter of jury, but not not in every single case. When there's no evidence to suggest. I mean, I don't want to get into the facts of the case because I don't think you want to either. But that would our motion would be based on that, is that there are two defendant drivers, and you've got to prove your case as to both.
Yeah. Okay. So let me look at these outstanding motions. I think y'all need to go ahead. I'm going to grant the continuance. I'm going to tell you that right now. I think y'all need to go ahead and talk, because I think that this case is sat long enough to where damages should be pretty much set, and y'all need to start going back and forth about whether this is a case that can be mediated or settled prior to trial. If we go to trial, we go to trial. Ms. Todd will tell you, I'm not scared to go to trial, but I need to know that y'all have done the work prior to trial for it to be a quick, clean trial. This is not a big issues here. Okay, so we'll continue it. Please expect that once you get stuff going, I don't know how much, if Mr. Riley is ever served, I'm not sure how much discovery would happen with him, because I don't know that an answer would ever be filed, but kind of anticipate that we're going to try this summer.
And so, sorry, Your Honor, are we allowed to file our motion for summary judgment?
Yeah, sure. Mr. West, I don't tell you how to try your case. If you want to file, like I said, I decide whatever is put before me. That's not a problem. I was just having an issue making the connection between whether the trial is bifurcated under the under Title 51 or whether whether it's a motion for summary judgment that narrows some issues that may not need to come before.
Right. Yeah. Yeah.
So, do what
so
you do.
yeah, and just to clarify, the summary judgment would be a dismissal of my client. That would be what we would request.
Okay.
That's why, that's where the bifurcation comes in. Unless I'm not making myself clear, which is possible.
That's a little bit clearer to me then.
Okay.
Well, file it. We will get you on a hearing calendar so we can hear it and figure it out.
All right. Thank you very much, Your Honor.
Okay, but in the meantime, y'all go ahead and continue and exchange the information because this case has got to be resolved some way. It's either going to be dismissed, settled, or tried.
Okay.
Judge,
I'm sorry, what?
In regards to the mediation, will that be an order for mediation to the Clayton County ADR office that we can?
Yeah, that's fine with me. Y'all can choose your mediator, but I mean, since we have them here, it's probably a less expensive option also. Do
we need an order from Your Honor to do? No. Okay.
Do not need one, but should you find that you need one, just contact Ms. Powell and she'll pull one that we've used and I'll sign it.
Okay, will do. All right.
Take
thank
care.
You.
All righty. Yes, you may.
Thank you.
All right. The next case that I have is Flores Biede, Villanueva, and Dari Scriven. Oh, that was dismissed. Okay. That's where it's coming from. This case, Demia Hudson versus Michael Reynolds, that was another case for Mr. Beard, and that case was continuance was granted. So they're still in discovery. The Lenora Scurry versus Saeed Hassa, continuance was granted, that it continues in discovery. And the next case that I have is James Phillips versus John Doe, PN Enterprises, Inc., and XYZ Corporation.
Your Honor, Keith Prater for Mr. Phillips.
All right.
And this is Christy Bankston for PN Enterprises.
Okay.
I will report that my announcement is that it would take 4 days. I don't think 5. We've got 6 witnesses. We may be able to take the treating physician and PT by deposition.
Is this over 150,000? Are we bifurcating?
We filed a motion for bifurcation back in September, Your Honor.
I was going to say probably.
And we, this is a premise liability case, and I have been listening to you do your spiel about I promise you that's something everybody's talking about, not just the judges.
We're clear.
I can tell you what my position will be, and we'll have to get you, motions on it, just like you were talking about earlier with Jason, Rick, on this. This is a little bit more of, was there a duty, was there a breach before we ever even think about getting to whether or not it caused damages. So this is one where I think it's a little bit, because a lot of times they're what I'm seeing is I'm getting a conflation between, oh, well, if you're going to argue, a breach and damages, and you actually have to argue proximate cause at the same time, but I'm not getting to the proximate cause because I got to get past whether or not a duty was breached before I get to whether or not it caused anything.
Is this an invitee versus one of those invitee versus, oh gosh, my brain just went out, issues?
He was an invitee.
He was an invitee, but he was in an area he was in the Bay Area of auto shop where everybody works. So he wasn't in like the general area where
Gotcha. Okay. So I can see that would be an issue. Possibly. All right.
That's disputed. But.
Okay. See, that's why this makes it a genuine issue for a trier of fact. Here's the question. When I look at the first paragraph under 51, what is it, 51-1233, where it talks about the first phase of the trial deals with finding fault. What is your definition of fault? And what is your definition of injuries? Because as I stated earlier, do the injuries stop at the point where we record that there's an initial impact or some impact or collision of some sort, and then we don't do anything past that? Like, okay, he's laying with a head injury on the deck of the bay. We can't talk about anything past that, which was Mr. Wellesley's. Essentially, he's been shot, but we don't get to figure out what injuries there were to the body. Only that he was shot. And I think that's a rather narrow view of it, but that's his view of it. What I want you all to talk about and suss through is those two concepts. Fault. What does it mean to determine fault? What you can argue or bring into that phase of the trial for fault, and injuries. What does it mean to determine fault for injuries, and what comes in with respect to injuries? What is the limitation of what each of you can argue on those issues? And that's what I want, because every trial is essentially what we all agree it is. And even though there are some statutes and rules that go for it, once we make a plan and we know what the roadmap looks like, then we get a clean trial. What I don't want is to have to, every time a statement is made from the witness stand, we got to stop and figure out if we're still on the roadmap. Okay.
That makes sense. There's not a consolidated pretrial order filed in this case, Your Honor. I apologize. I did not come into this case until January the 14th, so a little less than 30 days ago.
Yikes.
I have started on it. I would ask that maybe we could be kicked to the March calendar so that Keith and I can talk about it.
Everybody wants to be kicked to the March.
Well, that's because I'm honest with you. I literally just got on this case, so
I would not opine. I would opine that the after March calendar.
Mr. Prater, she said March. You were like, nah.
I'm easy.
Summertime, early fall is what I'm thinking. Well, honestly, Keith, let me break in for just 1 second. I'm sorry. I don't mean to interrupt you. Neither Keith nor I were there when this case was mediated the first time back in September. And from my review of the prior attorney notes, it looks like there was missing information. Now, if Keith has gotten some of the information that was missing, it might be more fruitful to try to mediate this the second time around if we can get everything together. Because I think that's part of the problem is there's missing things. We're missing things, if that makes sense.
Exactly. I have been herding cats with regard to getting phone records of several individuals. But I've only been in the case since mid 2025, so I think five months, 6 months.
Okay. I'm like 3 weeks. He's 5 months. So yeah, there's not.
Yeah. I heard the court say that the court has lined up cases for its March calendar. So I was saying the calendar after, but
yeah. Now, see, the difference is they line up, but by the time we get to trial, right now, almost every case that I've talked to today has some issue as to why they should jump off the ledge. And so it's going to be, I think I'm going to have to change my scheduling orders to accommodate the new bifurcation process and get to the point where we're talking about these issues earlier than this point, or earlier than when a motion comes before me.
It's I'll tell you, I have one that's the same week as this, February the 23rd. So I'm going to Carroll County tomorrow for another one of these, but at least the one in Carroll County is admitted simple negligence. So and is under 150 because he's capped at 100 anyway because of the UM policy. But what I have suggested on these that I've been on in other courts is to say if liability, if liability is admitted on a case, then those move to the front because you don't have to worry about bifurcation. And then bifurcation stuff is handled at the same time as motions in limine, have to be filed 30 days before trial. That's what I suggested on my last scheduling order.
And Judge, my hope is the Court of Appeals or the Supreme Court will take up the issue and clarify it, because I'm old and I don't get the tort reform.
Yeah, I'm with you, Mr. Prater. I know I look surprisingly young, but I am so with you. I was, when I had this discussion earlier with Mr. Woodard and Mr. Wellesley, the issue that I have is that I've done apportioned trials before, but when we have to start sussing out what we can say and can't say, and what, if we don't say it in the first phase, we can't say it in the second phase, and it gets so complicated that it just lengthens the process. And so if the point was to kind of make it easier to get these cases resolved, then that's going to be because all of them settle because nobody wants to go through this process. It's not going to be because we get to trial easier or the trial is easier to conduct. So
I wait till you have to deal with the whole anchoring stuff and if the defense steals and what can be said and what can't be said, because that was a recent issue in one of our cases as well. So it's there's a lot in this bill that is making everybody's life a little difficult right now.
Yeah, Mr. Woodard, I think, wants me to be the maverick and jump out there and find that there's some constitutional issue that the appellate court has to take up. I don't feel that I am so led, but I'm gonna reread the briefs and see, because I didn't see that. I mean, I saw it that he's arguing that, but that's not my feeling, but we'll see. The issue that I have is that, unfortunately, the legislature does not have enough trial attorneys, or attorneys who've had to prepare for trial and go through trial, and they don't, while they think they're making things easier for one party or the other, they're just really muddying the water for all parties. And I don't know, as much as the defense bar seems to be jumping up and down about it, I don't know that it is the boon that they think it is.
Yeah, and I will tell you, as a member of the defense bar and as well as the Georgia Defense Lawyers Association, that we are right there. That is our sentiment as well. I mean, we're going to represent our clients zealously, but you know, I had colleagues who went and testified when this bill was being drafted, and some of the issues that we talk about, they're complicated. It's like you told the gentleman earlier who runs the car business. I'm not going to pretend like I know how to run a Cadillac. You don't pretend like you're a lawyer. Well, guess what? We have a citizen legislature and they don't have any idea. So it goes right over their head when they're in those committee meetings. And then they're trying to meet in the middle, and we're getting muddled stuff.
All right. So this is, so do you want the opportunity to mediate again? Is that what you're saying? You think that would be helpful? Or do you want to just sit down and have some informal exchange of information and possible settlement talks?
I'm at Christie's leisure. So.
I mean, I would like to do, and Keith, you can tell me what you think about this, because I like deadlines and I like dates, because those are good. People can hold me to those. I like getting orders that say you have to mediate by X, or getting a scheduling order that says, let's lay this out. Mediation's done by X, experts are done by X, so that we have solid dates, so that the next time we come before you, those dates would have come and passed, and there is no excuse why it's not done. If that makes sense.
Yeah,
it does. I would like to, Judge, consider the issue of bifurcation in the scheduling order. No later than X number of days, plaintiff announces or defendants announces the trial needs to be bifurcated.
Well, we've already filed our notice of bifurcation. We did that.
Yeah, they filed the notice.
That's right.
But I would suggest that if we get a scheduling order, that the scheduling order says something like this case is going to be placed on the, and I'm just throwing a date out here, so don't hold me to it, but
I got you.
The July 20th calendar, all motions in limine, Dalberts, and memorandums of law on bifurcation are due 30 days prior to the pretrial. That way you have them so that you can have them in front of you to rule on you timely before we even get to them.
Mm-hmm. Yeah. Some of these things used to be so simple.
I know.
But we will, let me consider, let me talk with, I get what you're saying. I am persuaded, but what I want to do is speak with my case manager and staff attorney and get you some dates.
Okay, that works. And we can go back and forth. I mean, Keith and I think I had a case with him 15 years ago. He's been around a while. So I think we can, and he's in my area. I'm over in Fayetteville. He's down in Noonan. So we can chat and, go back and forth on those dates. And if the court wants us to take those dates and then put them in an actual proposed scheduling order, that's something we can do as well.
Yeah, we got a couple that we like. So we'll pull those up and kind of play around with those.
Okay.
Thank
you. Ms. Tolles, I did not mean to hold you, but I know that you're probably here checking on a case that may have already been either discussed, or I think they were granted an extension.
Yes, Your Honor. No one had said that they needed any assistance, but I just wanted to check and make sure.
Thank you for checking on me. I think we are good.
Okay.
Yeah, because the next case was dismissed. Paris Metcalf versus Host International.
Mm-hmm.
And then the next case after that is Samantha Rogers versus Ibrahim Sese, and Novo Indemnity and Stafford Transport.
This was one with the Villanueva is the last name.
I have Samantha Rogers and Ibrahim Sese.
Oh, okay. Yeah, I was checking on Flores baby.
Yeah, that case was moved. So I think that was
Okay.
continued.
Yeah. Thank you so much. Have a good
All
day.
right. Yeah. Thanks, Ms. Bankston. Ms. Powell, so on Rogers, I don't see anybody here for that. Were they coming or did they ask for continuance?
No, everybody is going to appear at the time listed on the calendar. So they should
I'm
be
sorry. Did we miss?
We got lucky because some folks showed up early, but they should be here at 3:30.
Okay, what time is it?
2:30.
Oh, okay, I can eat. All
Yes,
right.
ma'am.
So so they're the last case and they'll come back on at 3:30. Is that correct?
Yes, ma'am.
Okay, so I'm gonna go ahead and log out so I'm just not taking up cloud space, and then I'll come log back on right before the 3:30.
Yes, ma'am.
All right. Ms. Powell, we need to get with these bifurcations, which is gonna take a lot of more time for motions practice. So we need to change some things. Ms. Val, we need to meet and change some things.
Yes, ma'am. Do you want to do a Zoom call today to talk about? Do you want some time to think and we get something on the calendar later?
What's tomorrow? What's tomorrow, Ms. Val? Is that
arraignments?
Yeah, we're gonna need to
Let's talk about it a little bit when we in court on trial date, the 23rd.
Yes.
Yeah, because the easier cases are going to go out first.
Yeah, that works. All right, cool.
Sounds good. Judge, is there anything that you need in preparation, or just take the information that we learned today and think about it?
Yeah, just pull that stuff we talked about the other day, pull those and let's play around with them so that we can get them published as quickly as possible. And then we'll finalize.
Yes, ma'am. Sounds good.
All right.
See you at 3:30.
All right, thank you.